46%. 46.
Yes.
With due respect, my lord, I'd like to mention item number 44. One miscreant has come before your lordship is for restoration, my lord. So may I pray for a bit upgradation after exhausting motion matter, my lord? Kindly allow, my lord. Only restoration matter.
Okay.
Deeply obliged. Item 44. Deeply obliged.
Please, Your Lordship. Item number 27. And take up another 2 years. 27 years. At 2 p.m.
Okay.
Obliged.
Oh, at 2, not at 2. There goes another day because we are taking up APSC matters.
After motion. Yeah.
If I do,
Immediate after motion.
Obliged.
May I please your lordships? Lordships, I beg to mention item number 30, lordship. Lordship, this matter may be possible for the day, lordship.
it goes for 2 weeks. 30.
Deeply obliged, lordship.
May I please your lordships? Lordships, item number 45. This is a case of 17 lordships. And it was hard earlier also. So it may be upgraded lordships.
We can't say right now because we are taking up these matters, this bench at these matters till 2 o'clock. We'll try to.
May I please, your lordship? I beg to mention item number 17. May be possible for today, your lordship.
17.
17, your lordship.
Okay, same 2 weeks.
Possible. May it please, your lordship? Lordship, I beg to mention item number 16, lordship. May it possible for the day, lordship.
Okay, same order.
Obliged, lordship.
May I please, your lordship? I beg to mention item number 14, lordship. Kindly, lordship, pass for day, lordship. My senior is suffering from eyes disease, lordship.
Okay, 14.
14.
Nice.
Please, your lordship, I beg to mention item number 21, your lordship. Only possible the matter for that day.
21. Okay, same order.
Okay.
May I please, Lord? My lord, 4 matters have been listed, my lord. Item 4 I will do. Next item 12, 39 and 41 may kindly be deferred.
12.
12, 39, 41.
Well, 39.
And 41.
41 is a review matter of 21.
Short.
Okay. Okay.
Highly obliged.
Daily list item 1 for motion.
May it pleases your lordship. Lordship, in this matter, it's like just like a mercy petition, lordship. If one chance is given, she will abide by, even a short date is given to her, she will abide by that, and she will try to prove her nationality, lordship.
Motion দিব পাৰে।
Yes, Mr. Sharma.
Lordship. Lordship, I think Lordship, there is no infirmity in the opinion, Lordship. If Lordship will see on earlier occasion, Lordship has pointed out that the certified copies obtained by the proceeding Lordship prior to opinion passed by the learned tribunal, Lordship.
That's why she is not making any submission.
Yes.
She's praying for mercy. We'll examine the records. If we can do anything, we can see. Otherwise, it will be listed again.
Yes, lordship.
We are not assuring you anything, but
Yes,
let
sir.
us see the records and then
Yes, I have checked the records. I have each date I have noted also, Lordship. This is the reason I don't want to submit on marriage.
it's okay. We'll examine.
Yes, Lordship. Yes, Lordship.
There's no meeting of mind right now.
Yes, Lordship. Yes. Lordship.
Chamber. Just record the names also. Hold.
Deeply obliged, Lordship.
For motion, item 2.
Hey, please, Your Lordship.
Opinion is at which page?
Opinion, annex for page number 33.
33.
Yes.
Twenty-four opinion. There's only 24 opinion. I bet 37. 37. My contested. It's a contested matter. We
Yes,
give a bail.
no.
You have done the amendment?
Yes, Lordship.
Opinion is at page 33. Ms. T. Begum, learned counsel for the petitioner. Respondents are there, Mr. M. Islam on behalf of AI Ali and Ms. S. Barwa, CGC. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the Lanet Standing Council for the FT matters. Bail of rupees 5,000 within 10 days to the satisfaction of SP Border,
SP Border Borpeta.
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 Name the appliance.
Item 3.
Pilot in this case, only LCR was performed.
No, not full for.
You obtained the instructions.
Lordship, verbal instruction, I have received, Lordship, written instruction, I have not received, Lordship.
What does they say?
Lordship, it was treated like a press reference, Lordship. And Lordship proceeding never disclosed about the earlier proceeding that he was a declared foreigner, Lordship. So Lordship. On the same reference, Lordship, another notice was issued, Lordship, and Lordship. He appeared in the press reference also, Lordship, but he never disclosed that he was declared earlier as foreigner, Lordship.
You can't delay the matter, you'll have to get it by Wednesday at least.
Written instruction, lordship.
You get it because it will be very relevant.
Yes, lordship.
Uh, Mr. Hawk, where is the previous reference? Earlier order of reference, where is
Page
that?
56.
56. And where is the second notice?
Is 65, my lord.
65. Or we can close the matter, give him direction to appear and then.
Yes, yes, lord.
That will be.
It is better, lord.
That will be better.
Yes. Declare করে না এখন নোটিশখন আপনি চ্যালেঞ্জ করেছে নোটিশখন ফেলিত হয় বুলি আপুনি আপুনি তো ইস্যু অৰ্ডাৰ চ্যালেঞ্জ কৰা নাই ন কৰিলে তেতিয়া কথাটো বেলেগ হ'ল হয়
Mr. S. Hawk, we are disposing of the matter. Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard the respondents are there. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for quashing of notice issued on 31/8/2024 in connection with FT 4th /13 SHYM /19 is 65. Issued by so and so. Requiring appearance of the petitioner on 4/10/2024 next paragraph. The case of the petitioner is that by an opinion dated 28/8/2023 passed by the learned member, Foreigners Tribunal 4th Dorong Mode in so page 56. Arising out of FT case number so and so, reference case number so and so, because she was already declared to be a foreigner. Post 25/3/71 series. Next para. This court, by an order dated 28/3/2025, had posed a query to the learned counsel for the petitioner as to whether the previous opinion was brought to the notice of the learned tribunal.
ডিসক্লোজ করা নাই ভাবেলি করছে
You have any answer to that? No. We had put a query to you whether you had brought the earlier opinion to the notice of the tribunal.
My lord, no, my lord.
No. Stop. In response to the said query, the learned counsel for the petitioner has submitted that as per instructions received by him, the petitioner has not brought the previous opinion to the notice of the learned tribunal. Next paragraph. By order dated 9/4/2025, the court had asked the learned standing counsel for the FT matters to obtain instructions regarding issuance of notice dated 31/8/2024 by the same learned tribunal after delivery of opinion dated 28/8/2023 in at page 56, case number so and so, so and so. Full stop. By an order dated 2/5/2025, the matter was deferred to enable the learned standing counsel for the FT matters to obtain instructions. Full stop. Next para. The upon instructions, the learned standing counsel for the FT matters has submitted that as per verbal instructions received by him, he has not received any written instructions. Next para. Under the circumstances, having noted that in connection with the SP within bracket border apostrophe S reference number FT case number 218 of /07 dated 36/2007 in respect of which a fresh notice was issued on 31/8/2024. There is already an opinion rendered by the said learned tribunal on 28/8/2023 in connection with page 56 FT 4th case number so and so. Next, under such circumstances, the court is inclined to close the writ petition with the direction to the petitioner to appear before the learned member either in person or through a learned counsel duly instructed, so as to bring the previous opinion to the notice of the learned tribunal. Full stop. Thereafter, the said learned tribunal shall pass an appropriate order in connection with the said notice dated 31/8/2024. Full stop. Next, per order, if any, passed by the said learned tribunal, pursuant to direction of this court, shall be communicated to the Superintendent of Police within bracket border, Mongoloi. as well as next para, the Secretary to the Home, let a copy of this order be also transmitted to the Secretary to the Government of Assam, comma, Home and Political within bracket B, bracket close department. So as to examine as to how after rendition of an opinion, a fresh notice can be issued to the petitioner. Accordingly, the Learned Standing Council for the FT matters shall communicate a copy of this order to the said authorities. Next, the matter stands disposed of.
Obligation.
We are saying that you can appear through person or through your counsel, whatever be.
Obligation.
Disposed of at the motion stage without issuance of notice on the respondents.
Item 4,
Which page is the opinion?
My lord, page 73. And my exhibited documents are 75.
'73.
Yes.
Is it 24 opinion? We give him bail.
My lord, there was some delay.
Still it's 24, we are giving you bail. If you are, as a thumb rule, when you are coming within a year, we are not questioning you or anything. It's only beyond 1 year that we are not granting bail. Some people are taking up very casually. Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner. All the respondents are there. Opinion is at page 73, 6/5/2024. Notice extra copies within 2 days. Call for the records. Therefore, bail is opposed by the Learned Standing Counsel for the FT matters. Bail over 10 days time to take bail is 5,000 to the satisfaction of SP Border.
No.
Nagaon.
Hello.
item 5,
May I please, your lordship?
Yes, opinion at page
Page number 42, your lordship, and except
40,
42, 42, your lordship.
42 is 21 opinion.
Yes, your
You have
lordship.
to wait for some time then.
In the meantime, the petitioner has been arrested. Your lordship.
Should not be deported.
Okay, your lordship.
He will not be deported out of the country.
Okay, your lordship.
Respondent number 4 may be corrected, Lordship.
Huh?
Respondent number 4, Deputy Commissioner Morigaon.
Or then you do it, we'll take it up thereafter. How can you be so casual? Every day we are passing orders and you don't check up. Also as a represented, is the authority whose arid as respondent before does not exist. So the Learned Counsel for the petitioner is granted liberty to amend the cause title by implementing the appropriate officer as respondent before by submitting an amended copy of the cause title to the AOJ FT section positively within 19, no, sorry, dated 19/5/2025. So thereafter, the matters be listed again in the motion column. We'll be starting to dismiss all these matters. Where you don't impede, we'll give you liberty, but we'll dismiss it. Unless you start dismissing, we end up doing the same thing. And I'm just addressing the members of the bar. If you find a mistake in the name and in the cost title and in the affidavit, matters will be summarily dismissed. Orders passed in the open court will be recalled and matters will be dismissed. Let us check up. We are fed up of doing this work. We end up till 8 o'clock doing these corrections and irritate ourselves in the process. Next time there's any mistake in the names in the affidavit and the cost title, those matters will be dismissed summarily. Next,
Item 6.
Right, yeah. Just opinion at page 49.
just a moment.
Mm.
49.
Yes, sir.
You have to wait for some time for bail.
Yes.
Mr. N. Islam.
A. Ali, Lord.
A. Ali. Mr. A. Ali, learned counsel for the petitioner. The respondents are there. You are appearing on behalf of Ms. P. Barwa. Opinion is at page 49. Opinion dated 5/3/2024, passed by so-and-so in so-and-so, reference case number so-and-so. Notice extra copies within 2 days, call for the records. Prayer for bail shall be considered on receipt of records. Give a fixed date after 4 weeks.
June.
Oh, nice.
Item 7.
Include order page 37, my lord. 5/3/24, my lord.
Page number
37, my lord.
37. Mr. Rahman, you'll have to wait for some time for bail. But Mr. A.W. Aman and counsel for the petitioner, all the respondents are there. Mr. Islam on behalf of Mr. A.I. Ali. Page 37 opinion. 5/3/2024, passed by so-and-so in so-and-so. There are 4 reference cases, huh? 1, 2, 3, 4.
Amalgamated case of husband and wife, my lord.
Hmm?
The amalgamated case of husband and wife. It's a common order, my lord.
Common order,
My
okay.
lord, my lord.
Common order. You say common opinion. So both the petitioners are parties here.
My lord, my lord.
They make it petitioners. Yes. Notice returnable on 16/6/2025. Extra copies within 2 days. Prayer for, call for the records. Prayer for bail shall be considered on receipt of records. List on so-and-so.
Grateful.
Item 8.
Opinion on 42.
Just one. Opinion page number
42.
42.
Lordship, same correction should be done. Lordship. Respondent number 4.
No, in your copy it's corrected.
Oh,
I
yes.
checked up. We make correction in their copies also, otherwise do that
Yeah.
correction.
Yes, my lord.
Huh.
Treatise type of question.
Okay, your name?
MD Mehdi.
Mrs. MD Mehdi, learned counsel for the petitioner. Okay, respondents are there. Opinion at page 42, dated 28/2024. Passed by so and so. Notice extra copies within 2 days. Call for the records. Therefore, bail is opposed by the learned standing counsel for the FT matters. Considering the projection in this writ petition, 10 days time to take bail or rupees 5,000 to the satisfaction of
No go.
No go.
SP Border Nagaon.
File your business.
Item 9 for motion.
Yes, Mr. Sipal.
My lord, input opinion is at page 81 and accept 20.
Page number 61,
81.
81. Mr. A.R. Sigdar. Respondents are there. Opinion at page 81, dated 28/2/2025, passed by so and so and so and so. Notice extra copies within 2 days. Call for the records. Same amount of bail proposed. 10 days time to take bail or rupees 5,000 to the satisfaction of
SPB Gwalpara.
SP Border Gwalpara.
Keep level.
Item 10.
The impugn opinion, page number 66.
Page
66 also.
six.
Yes.
Okay. Mr. Sharma, you're granting bail.
Lordship, 23 opinion, Lordship.
But
Oh, it's 23.
Yes, yes.
Okay, okay.
Lordship, kindly see one thing I'd like to point it out. Here the date of argument, kindly see Lordship. 7/12/2021. The opinion rendered on 7/6/2023. Lordship, how she could know?
We can't help it.
Lordship.
Mr. AZ Ahmed, counsel for the petitioner. Other respondents are there. Opinion is at page 66. FT case number so and so. There are 4 references. So and so, so and so, so and so, so and so. Opinion dated 7/6/2023, passed so and so and so and so. Notice extra copies within 2 days. Call for the records. Full stop. The registry shall issue requisition at the following email address of the said learned tribunal, so as to enable the said learned tribunal to send either a scanned copy of the records or the original records to this court. So as to reach this court on the next date of listing. Next para, we take notice of the contents of the opinion dated 7/6/2023, wherein it has been mentioned that the date of argument was 7/12/2021 and the date of opinion was 7/6/2023. Full stop. In this regard, we direct the learned standing counsel for the FT matters to send a copy of this order to the Secretary, Home and Political B Department, so as to enable them to examine as to the inordinate delay of around 1.5 years in rendition of the opinion. For departmental use only, without requiring any report to be provided to the court. Next, the prayer for bail shall be considered on receipt of records. List on so and so. Give a fixed date after. It will be 16/6. We're giving a fixed date. We are requesting you to send the copy of the order to the Home Department, Mr. Sharma.
Yes, Doctor.
Let them examine this.
Yes, Doctor.
Subli item 46.
They have received instructions. In fact, the state government is now in default. But Mr. Sharma, if the state government is in default, we'll have to issue notice to the state government. They will have to compensate. Central government has written in 2014. For 11 years, your officers did not take steps. It will.
We have made the state government as a party.
That's why.
The notice is notice in this state.
Notice me go.
Mr. Sharma, we give you 10 days time to have to uh, consult the Ministry of External Affairs and do the needful. We are also issuing you notice why, when there is a standing policy of 2014, you did not comply with it.
Notice.
Uh, this order you will have to type in here. No? And Mr. D.K. Agarwal, learned counsel for the petitioner. Also heard Mr. M.R. Adhikari, learned CEC appearing for respondent number 1, and Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 2. It is recorded in the order dated 28/4/2025, as well as order dated 9/5/2025, that the petitioner had been taken into custody on 12/11/2020 for entering into India without any valid travel document. He was produced before the court on 13/11/2020 and by an order dated 18/8/2021, the petitioner was convicted to suffer simple imprisonment for 6 months and to pay a fine of rupees 2,000 for offense under Section 14 of the Foreigners Act, 1946. And he was further sentenced to 6 months simple imprisonment with fine of rupees 2,000 for offense under Section 6 of the Passport within bracket entry into India bracket close rules, 1950. This you'll get in the last order. Huh? So stop. Accordingly, certain directions were issued. After taking note that as on 9/5/2025, the petitioner had spent 1457 days in illegal detention. Next paragraph. Pursuant to the said orders, the learned CGC has produced a copy of written instructions dated 8/5/2025 received from the Government of India, Ministry of Home Affairs, within bracket Foreigners Division, issued by the section officer within bracket F space Roman 7 capital. Stating therein that a consolidated instruction has already been issued to all state governments, FRROs and FROs, regarding procedure to be followed for deportation, repatriation of a foreign national by Ministry of Home Affairs communication dated 29/4/2014. Next paragraph. The contents of the said letter is quoted below. Next paragraph. as the Ministry of Home Affairs has indicated that the deportation of the repatriation must be done by the state government in consultation with the Ministry of External Affairs, the court is inclined to implead the Ministry of External Affairs, Government of India, represented by its secretary. Can we have this address, address of MEA?
The address of that,
Okay.
yes.
Or you'll get it in the net also. Ministry of External Affairs, that so and so as respondent number
3 minutes.
3. Let's respond to 3. First of all, the registry shall do the needful. For effectuating the amendment to the cost title. Next para pending the implement of respond number 3, court is inclined to issue notice on respond number 3. Returnable in 2 weeks. Returnable so and so. You don't give a date. 2 weeks, give a date. After 2 weeks, give a date. So and so. First off, extra copy of the writ petition be served on the learned CEC in course of the day. Next para. The court is inclined to issue notice on the Commissioner and Secretary to the Government of Assam, Home Department, as well as to the Ministry of External Affairs, Government of India, to have urgent consultation in the matter of deportation of the petitioner to the deportation of the repatriation of the petitioner, namely so and so, to the Federal Republic of Nigeria through its embassy located at New Delhi. Next para, in the order dated 9/5/2025, we've already issued certain directions. Of the respondent numbers 1 and 2. All the respondents shall do the needful in terms of the said directions. Now, this has the did you have this order copies furnished to the Superintendent of Transit Camp?
Yes, Your Lordship, I have posted them. Yesterday, they have also written a mail to the Nigerian High Commission. Delhi.
Okay, next para. The learned counsel for the petitioner has submitted that the copy of this order has been communicated to the Transit Camp Matia Gwalpara, and as per instructions received by him, the superintendent of the transit camp has sent an email to the Embassy of Nigeria, of Republic of Nigeria. Next paragraph. We hope and trust that by the next date of listing, the respondents do the needful for the deportation of the repatriation of the petitioner to his country of origin. Next paragraph. As it has been communicated by the Ministry of Home Affairs that consolidated instructions had already been sent to all the states way back on 29/4/2014 for deportation of foreign nationals, deportation of the repatriation of foreign nationals. And in this case, as on 9/5/2025, notwithstanding the said instructions dated 29/4/2014, and as per the where it in 14, 1457, where you have written, just see, 1457 where you written, in bracket you write, calculated at 1608 days in the communication dated 8/5/2025 by the Ordnance Division, Ministry of Home Affairs. The court is inclined to put the state to notice as to why the state should not be ordered to pay compensation, monetary compensation to the petitioner for his illegal detention. Next paragraph. The learned standing counsel for the national learned additional senior government advocate shall transmit a copy of this order to the respondent number 2. List on
2nd of June.
second of just before that also, let a copy of this order be downloaded copy of this order be transmitted by the learned CGC to the Ministry of Home Affairs and the Ministry of External Affairs to bring the order to the notice of the said authority. You will get it. Just ready for master.
Copy of the instruction has also been marked to Chief Secretary Assam.
Pardon me?
Yes. Well, copy of this instruction, Malak, which I just placed, has been marked to Chief Secretary Assam also. Malak.
Oh, yes.
Copy 2.
Yes.
Number 2. Malak.
The copy of instructions dated 8/5/2025, copy of which is stated to have been marked to the Chief Secretary of the Government of Assam. With a request to provide factual position, including status of nationality verification in the case of the petitioner. Is made a part of record. Okay, just we may have before that you say in the event the authorities take an appropriate decision, it will be open to them to implement the same without waiting for any order of the court.
All right.
Supplementary list item 47 for motion.
Yes. Which page is the opinion?
My lord, may I please the lord's opinion?
my lord, my matter, my lord, relates to, my lord, police action.
What's a police, this is
Police action, my lord, and which is, my lord, not what the police of Hategaon police station is doing, my lord. I am the informant. Now, I have been harassed, my lord. A detailed narration of facts, my lord, I have stated on oath before my lord, is a paragraph 23 and 24 of my petition, my lord. If I may be allowed to draw my lordship's attention to para 23, my lord, page 30, my lord.
You see,
My lord.
prima facie, we are not satisfied with this petition for a
Petition.
simple reason
My lord.
that after the
Sakari Basu.
Supreme Court
Sakari Basu,
decision on that Sakari Basu,
My lord.
Yes, Lord.
My lord.
you'll have to comply with that requirement, and then only we can entertain a writ petition.
My lord, that is, my lord, I have also gone through the judgment, my lord. With all respect, my lord, what I beg to submit, my affair has been entertained, my lord. My affair has been entertained. It is not like that my affair has not been entertained or it has not been registered also. General diary entry has also been, I am not agreed with that, my lord. Once, my lord, I have lost the affair, I being the informant, my lord, I should be facilitated with the police protection and the other entitlement on, my lord, which I am entitled for protection of my life.
This
and
protection, for that, there is a Home Department guideline. You must fit in that requirement
No, my lord, those they are
after
not
the
following.
risk assessment.
Lord, what they are doing, my lord, in a hush manner, my lord, I have been summoned to the police station, my lord, and my lord, an agreement has also been forcefully taken at the behest of the police. Now, that agreement is my lord, is such type of nature, my lord, it will have a bearing on my, lord, title suit, which I have lost before the, my lord, learned trial court below, my lord, for cancellation of the initial agreement for sale, my lord. That is the issue, my lord. Now, the police is now completely, my lord, I should not say these words, my lord. They are now following the dictation of those persons, my lord, who wanted to forcefully compel me, my lord, to go with the sale, my lord. That's if my lord call for an instruction, my lord, everything will come up, my lord.
Since against the police, my lord, there is a
No,
provision to file for.
Just
Lord,
complaint.
we
Lord,
have a reservation.
as an extreme urgency, my lord, for the protection of my life and liberty, my lord, I am taken, my lord, recourse of this provision under, my lord, my lordship's interference, my lord. I know, my lord, that the Sakari Basu, there is a strict provision has been made, my lord, that the, in such a situation, my lord.
No, it's not that. You see,
My lord,
if you entertain a writ petition like this,
my lord,
we'll be entertaining a very highly disputed questions of fact.
my,
Just for an example, if you can come to page 26.
my lord. Yes, my lord.
Here you have said that the petitioner was shocked at the motive behind respondent number 6 in not proceeding ahead as per the terms and conditions of the agreement for sale.
My lord,
Respondent number 6 has failed to pay the complete advance amount.
my lord.
From the conduct of the respondent number 5, it is very much clear that the respondent number 6 is not interested and willing to get registered the sale deed by making payment
My lord.
of the balance amount and remaining balance sale consideration for purchasing the suit property at so and so. So therefore, you see, it is essentially a issue which is covered by the provisions of Specific Relief Act.
My lord, that is already there, my lord. That,
But then,
my lord, that is only, my lord, my here in this case, my lord, I am not seeking any relief for the, my civil rights, my lord, or the rights regarding the property, only my life limb. My lord, may kindly appreciate the whole day, my lord, I had been detained in a police station, my lord, all the CCTV footages are there. My mobile phone had been seized by the officer in charge himself, my lord. Such type of situation is, my lord, in this case, my lord. That's why, my lord, with all respect, my lord, my humble submission before my lord is that, my lord, is that the police is exercising a power with very high-handed nature, my lord. That to an informant, my lord. My lord can
please
understand their
come to page
motive.
37.
My lord,
Please come to page 37. Your first prayer is
my lord.
to direct the officer in charge to register an FIR. Now you say that the FIR has already been
No,
registered.
my lord, what has
FIR is not
happened, my lord,
registered.
today morning, my lord, I have taken the instruction, my lord, that this affair has been entertained and it has also within the process of, my lord, registration. That's why, my lord, we are not pressing with the prayer A, my lord. The rest of the prayer, my lord, which I have made, my lord, my protection, that the police should not harass me, my lord. That must protection I am asking, my lord. If I am not committed any offense which is under the penal provision, my lord.
I know, my lord, that the reed court, my lord, the power, my lord, is very in this type of cases, my lord. But with all respect, my lord, I am, my lord, my children, my family, my lord, everything, my lord, had been harassed, my lord. My brother, my lord. An amount of rupees 3 lakhs had already been extorted, my lord, with the aid of the police, my lord. I have
You
specifically
know,
discussed,
whenever we try to read anything in this matter, we find it very amusing.
my lord,
For example, your agreement for sale.
my lord.
The agreement for sale is by a person who is not the title holder. He's neither an ostensible owner, neither he's a party who's otherwise authorized to sell. You come to page 50.
My lord. Akbar Ali, my lord.
Yes.
No, no, my lord, this is not the agreement. This is, my lord, what I have done. After taking the advance amount, my lord, I intended to purchase this property subsequently, wherein I have invested the advance amount, my lord. The original sale agreement, my lord, is at page 40, my lord, annexure 1. 43,
Okay,
my
what
lord.
is this?
I have
What is
given,
this page 50 then?
my lord, page
is-
50 is.
That is a deed of agreement, my lord.
This is, my lord, what I have done, my lord. Initially, I have taken the advance amount from the person concerned, my lord, respondent number 4 and 5. Now, my lord, by using that amount, this land I am going to purchase from this Akbar Ali, my lord. Subsequent sale, I have not suppressed anything, my lord. That where I have invested my money. Even, my lord, I am agreed to refund the money also. That proposal I had been given to them, my lord. Even then, they are not agreeing, my lord. That's why, my lord, my very limited prayer, my lord, that should not be my family and I should not be harassed in this manner. As the matter is in a civil court, my lord, they can go and contest there, my lord. If the honorable trial court, my lord, pass an order.
Where is your FIR?
My lord,
Please,
yes.
your FIR.
My lord may be pleased to find. My lord, the FIR is at page 69, 67, my lord, translated. And the vernacular, my lord, is at page 71, my lord. Two FIR had been lodged, my lord. First is at page 65 also. My lord.
কপিটা দিয়াই লাগিছিল মানে তাক এনেকে প্ৰভিজনটো আছে 175 এনেকে ডিপেণ্ড কৰি আমি মুভে কৰিব পাৰি পাৰে ঘৰৰ মানুহে দিব পাৰে ফাইল তাৰমানে হাতীগাঁও তেনেকুৱা এটা গেং ওলাইছে কিন্তু হ'ব চাই লওঁ গোটেই যদি কয় এইটো সেইটো কৰি দিব My lord.
The copy of your civil suit you have filed,
My lord, that copy I have not annexed, but the order I have annexed, my lord.
where is that?
Yes, my lord. My lord, maybe please. Page number 67, my lord. And 68 also, my lord. 68 is more specific, my lord.
68.
Yes, my lord.
What 68 and 70 years. 7 68. So that.
Clean stain না করানো হয় না, সেগুলো করলে plenty কাটবে না।
No, Mr. Bihar, we are sorry, we are inclined to dismiss this petition.
Not my prayer,
The-
my lord, is very
Sir,
clear.
No, you see,
Clear
we have gone through the documents.
My lord, my lord.
By reading these documents, it doesn't come to a full circle.
Regarding my lord, the
You
Self-
see, when a story starts, it has to end somewhere.
my lord. My lord, the story now at in the police station, my lord.
No, we don't know, but here also this is not a complete circle we are not finding. Somewhere there is a gap in between.
No, my lord, what I know, my lord, sometime it is very difficult to satisfy my lord with the all the incident which are not on record, my lord. But the incident, my lord,
He is
which-
not
my
fine.
No, not that.
My
You see, we are not on the incident which is off the record. Even on the record, there must be something which must come into place.
my lord,
First FIR is of 22/4.
my lord, my lord,
There you make a prayer that you got a video call. That's
Right.
all. Second is that you file a civil suit on 2/5.
my lord.
You get a what you call the notice is issued by the court.
By the
Then
time,
you file another FIR which is on 7/5.
my lord.
In the 7/5 FIR, you don't allege anything happened to you. You say that somebody threatened my brother.
My lord. Yes. No, my lord, what has happened, my brother and myself, my lord, is both the petitioner here, my lord, in this petition, not only myself, my lord. My brother is also before my lord, my lord. The money which has been taken forcefully by the police and in aid with the, my lord, huntsman is from my brother, my lord. My lord, may kindly verify, petitioner number 2 is my brother, my lord.
But then if the police has extorted money from you, then you have Police Accountability Commission.
That is there, my lord. But
Otherwise,
what
he
they-
filed
Lord,
before
what they-
commissioner also, my lord. There is a provision, my lord, to file against the police. If any police officer takes such action, he should file one complaint before commissioner. As per the
No,
provision.
no, we can
of
go to the, my
175
lord, commissioner if
PNSS,
the,
my
if
lord.
the FIRs
Section
are
3.
not been taken into record or.
No. Even if somebody,
My
if you are, if you are called into police station, there is evidence of you being there.
My lord.
The Commissioner of Police will definitely call for the records and the CCTV footage, and he will find it out.
Definitely.
If money has been
take-
extorted,
take action, my lord.
because the court would not enter into this original inquiry when you already have a police commission.
My lord,
And
we are not that the, my lordships go for my lord, to direct an inquiry, my lord. We are only seeking the protection of our life and, my lord, liberty, my lord, as well as, my lord, our.
that also you must,
My lord.
we must show us some case.
That is the, my lord, that is the, because now, my lord, I
Because
am.
the money of extortion, for that regard, you have no prayer.
No, my lord, the prayer which we have made, my lord, that the regarding the police action which they are now carrying out on an FIR which I have lost, they have invited me in the police station for recording. Now these persons, my lord, has created a gang. My lord, what they are doing, my lord, is, my lord, is very unfortunate, my lord, that the police is aiding those, my lord, henchmen, my lord, of the respondent number 4, my lord. That is the difficulty, my lord. That's why, my lord, I am threatening that if something happens to myself, my brother and family, my lord, then it will be, my lord. Now, my lord, I am in such a place, even I cannot come out openly, my lord. I have been threatened in such a manner, my lord. That is the morning's instruction. That's why, my lord, I made a mention urgently yesterday, my lord. If, my lord, just for a, my lord, just if the instruction is short, my lord, what is the real story is, my lord, can on next day can dispose of what, my lord, can.
No,
No. Once we call for the, you see, if we intend to pass an order,
My lord,
we would want it to bring it to a logical conclusion.
that is correct, my lord, that is correct. But, my lord, under extreme urgency,
Once
my lord.
the court issues a notice, it has
My
to be brought to a logical
My
conclusion.
lord, my life is in danger. That is correct, my lord, because I have talked personally with the person, my lord. If we come out, my lord, then, my lord, these persons are behind me. Even, my lord, such gang is operating in that area. That is the instruction, my instruction, my lord. Otherwise, I would not have also not suggested them to file a writ, my lord. Zulfikar Ali is my brother, my lord, petitioner number 2, my lord.
We accept a part of your statement that if your life is threatened, we give you liberty to move the commissioner of police.
My lord.
But we are not keeping this pending.
My lord.
If you feel that you are threatened as a citizen, you have a right to approach the commissioner of police.
My lord.
And if they are satisfied, they will initiate a issue. They will initiate action.
Then my lord can dispose of in that line.
We
My
are
lord.
disposing it of that.
My lord.
কমিশনার হলেও অলপ বাঁচিব মানুহটো মানে এটলিষ্ট দম নিদিব
Heard Mr. A.R. Bhuyal and counsel for the petitioners. Also heard Mr. P. Sharma, an additional senior government advocate, appearing for respondent numbers 1 to 4. Next, in view of the nature of order the court is proposing to pass, there's no requirement for any issuance of notice on the respondent numbers 5, 6, and 7 at this 5, 6, and 7. Next. From the materials available on record, it appears that there is a dispute with regard to the sale and purchase of a plot of land between the petitioner and the respondent number 6. arising out of an agreement for sale dated 21/10/2024. Stop. It is projected that in connection with the dispute, suit, which is registered as title suit number 256/2025, is presently pending for adjudication before the court of learned civil judge within bracket senior division bracket close number 3, Kamrup Metro, Guwahati. Next para. The learned counsel for the petitioner projects that the petitioner had lodged an FIR before the officer in charge, Hathigao Police Station, Guwahati, stop. It is projected that pursuant to the same, the police personnel are taking side with the respondent number 6. And it is also projected that certain elements, including the police personnel, are exerting pressure on the petitioners full stop. Next, it is submitted that although one of the prayers in this writ petition was to direct the respondent number 4, i.e. the officer in charge of Hathigao Police Station, to register FIR dated 22/4/2025 and 7/5/2025, but he has received instructions that the said FIR has since been registered. Accordingly, the learned counsel for the petitioner has pressed prayer number C, capital C, of the writ petition, whereby it is prayed that the state respondents, including the respondent number 4, be directed not to harass and threaten the petitioner or to commit any atrocities. Next para. Not as well as same paragraph. Accordingly, the petition has been filed under Article 226 of the Constitution of India. Next para. In light of the ratio laid down in the case of Sakiri Vasu versus State of Uttar Pradesh,
2008.
2008, bracket close.
USS. USCC, madam.
2 SCC 409.
40.
When in an elaborate discussion about regarding the power of the magistrate under section 154 within bracket 3 of the CRPC, and section so 1, 2, 3 and section 200 of the CRPC has been made. And opinion expressed with regard to the power of the magistrate to order a proper investigation and to take other suitable steps. Comma, the court is not inclined to entertain this writ petition. Next para. Nonetheless, comma, as a citizen, comma, the petitioner has a right to approach the Commissioner of Police, Kamru Metro Guwahati, or such other police authorities and or other forums available in the event the petitioner feels himself aggrieved by any police action. Comma, notwithstanding the dismissal of this writ petition, the said right of the petitioner can be exercised at any point of time. Full stop with the aforesaid observations. And in light of the decision of the Supreme Court of India in the case of Sakiri Vasu within bracket Supra, comma, this writ petition stands closed.
My lord, the petitioner shall approach the commissioner, my lord, within.
No, we have said you have a right
My lord.
that can be exercised at any point of time
My lord. The
or
commissioner,
any other forum.
commissioner can give necessary protection that.
That they have
Yes,
power.
my lord.
They have power. You see, threat perception
My lord.
is the issue. We have extensively dealt with the threat perception in other matters. We have extensively gone through the various circulars issued, the notification issued by the state government with regard to the threat perception. So it has to be complied with that.
My lord.
Since those prayers would again be dependent on your steps being taken and refusal.
Yes, yes, my lord.
Only then we get the
Exactly.
under
No,
220 it would be appropriate.
those requirements, my lord, admittedly, I have not gone through, my lord.
So that's why we are not making any observation.
My lord.
And how's your health now?
Lord, still under medication.
Still under
recovering,
medication.
my lord.
Okay, not yet fully recovered, that means.
No, my lord, the recent checkup had been done. The cells are being regenerated. That's the issue.
Regeneration started.
Started.
Good.
My lord.
Okay.
Highly obliged.
Item 11,
That is a lordship. I know in this matter, my lord, if you like, if your lordship, the last order 13 May 2024, my lord. The matter with the custody dealt matter, my lord. So far as respondent to file affidavit and given the address of the respondent number 6, there is no direction to take the steps on the first address to the respondent 6. So we are seeking that direction, my lord, so that we could take steps on the respondent number 6, my lord. And though, my lord, as per Office Note 25/1/2019, service complete for all the respondents. But thereafter, he address changed by the respondent number 6. He has not participated before this court, my lord. And accordingly, this honorable court on 14/9/2023 asked the respondent number 2 to give the correct address, present address of respondent number 6. And accordingly, they have furnished us to, my lord. So we are seeking time, praying for to take steps.
Just a moment.
Yes, my lord.
Okay. But I have a notice put idea. Right? Awesome. It's storage. I have storage. Proper. It's so super. Oh my dear. Yeah, this there are lot of flags. I'm not going to storage. Easily transport to Sikkim. Then you file I address into immediately. Okay, name it already at least two correction. Correction. Maybe step down. Hathor pura sub step down. They mean 1 to 6 main. So we file close. So 6 to 100. More than America from the money. So, the speed, this case, yeah. Yeah, he's already transformed. So, here the how to social. Ordinarily, he's from Sikkim. Oh, I'm not a department. So, Sikkim, over, I piece of some. So, the case.
Is the inquest report or the postmortem report available on record?
Yes, my lord.
Where is that?
They have furnished us, my lord. Pardon, it is also in the record of the government, my lord, the original records.
No, no. Which page we will find it?
Yes. My lord, in respondent number 1, affidavits, my lord, it page 87.
One.
Annexure A.
That's one number 5. That's one number 3. That's one number 2. That's one number 1, no? Seven to one, Miss Taludar. Miss Taludar. That's what I said. It will be yeah, this one was 17 years. 87, 77. It was 17 goes. He left side, dear left side. Yes, that's true. That's very secure potency. It's not that big. Simply cardiac notice. You must ask him. এই গন্ডগোল যে হয়েছিল এইটো নেকি? গন্ডগোল যে হয়েছিল নাগালেণ্ড হৈ পেলাই সেইটো নহয়। এইটো তুমি প্ৰথমে পাৰ্টি ইনভাইট কৰা সেইটো কৈ দিয়া এইটো নহ'লে তোমাৰ লাভ নহ'ব। বাকী এইটো এটা 6 মিনিমাম তুমি কৈ দিয়া এইটো। This report to additional activity. One 76 hours, servicing 176 hours. 176 hours. Mauritia Road, under this provision, we made an application. SPO document, SPO. SPO document, including in this too. Also, there's plus.
It is 10 years down the line. This is a repetition of 2015.
My lord.
And now we are in 25. We're still in the stage of what you call service report. But we don't find any worthwhile reason to continue with this repetition. Is a case, unless you can medically show otherwise. Have you read or not? I don't know. Page 90. Have you read this page 90? It's a postmortem report. Have you read it? You have not read it. Correct. The reasons are given here why the person died. The postmortem report says weight of the heart is 320 grams, fatty deposition all over the surfaces of the heart, aorta surface of left ventricle on the middle part shows pinkish like discoloration in contrast to the pale colorature of the rest parts of the heart. On atheromatous
Guess.
variable plaque seen deposited in the antima of arc of aorta. Coronary arteries narrowed on both sides with narrowing of the lumens of both coronaries, more on the left side, chambers of heart empty, valves healthy, acute chronic coronary insufficiency. The dead body does not have any injury marks. And therefore the person may have been arrested, but he has died instantaneously because of insufficiency in the coronary insufficiency. And that will lead to a heart attack and death.
Yes,
And it could be instantaneous.
in this matter, what happened, my lord? We made in 167 petition for magistrate inquiry on that, my lord. And inquiry, my lord, while magistrate inquiry conducted, we have enclosed the inquiry board. 14 witnesses were examined. Out of the 3 eyewitnesses, my lord, they have seen that there's a twisted his head, my lord. So regarding twisted his head by keeping 2 constables also evidence is also said the same evidence, my lord. So far as, my lord, injury, the medical report is injury, but he twisted his head, my lord. We are on that point, my lord. And even my father was not an FRNM accused, my lord. They at the that is fateful night, that is on 7/12/2012, my lord, at 12:30 PM, my lord, they entered my house and charged my elder brothers, Mrs. Najibuddin, and not finding my elder brother, they took my father there, my lord. That is respondent number 6, and even constable evidence was also taken. We are on that point, my lord. We made,
Where is that?
my lord.
Where is that?
Yes, my lord. Lordship, kindly have a look. Our additional affidavit, my lord, 110, page 46, the report of the Mesl inquiry. And in the inquiry, it is clear, section 50 and 50 is violation, this report.
Where is that?
Yes, my lord, Lordship, kindly, page 46 is the report, inquiry report. I'd like to take directly, my lord, page 47, very next page, sorry, 111, additional. Eleven, my lord, at serial number 6, my lord. During the inquiry, the following witnesses are examined on different dates. I am concerned, my lord, witness number 1, 2, 3, and
You are reading which page?
111, my lord, 111. Or inside page, my lord, 47.
111.
Yes, my lord.
Conducted by Chief Judicial Magistrate.
And I am concerned, my lord, witness number 1, Mohibur Rahman, Tajuddin Borbi, and Sahid Boruddin, and Constable Badrul Islam Borbi, who accompanied with the respondent number 6 on that date, my lord. That is witness number 9.
Yes, sir.
Is the GD entries available? Is there any order to call for the police records?
No, my lord. No, my lord. I have received one. Details report connection.
And even my lord, respondent number one in the affidavit say they still investigation is going on, my lord, in their affidavit.
That's number one.
You produce the status of investigation.
Yes, my lord. That
And the relevant, the original GD entry book.
yes, my lord. What will you do?
Entry. Original.
Status report of interest. Investigation going on. Page 85. 2022. No objection to the Lord Prophet.
The WBC criminal hole আছে নাকি?
সেটা একটু হেরি হয়। আমি তো প্রথমে আমি ইনভেস্টিগেশনের জন্য আইছিল। হ্যাঁ।
WBC criminal hole.
আমি সিঙ্গেল বেঞ্চ করেছি। সিঙ্গেল বেঞ্চ ডিভিশনাল চেক করেছি।
এটা criminal hole.
কোন ডিভিশনাল চেক করে ক্রিমিনাল করি। সিঙ্গেল বেঞ্চ করেছি।
Correction করে দেবো আর।
একটু কোর্টে অবজারভেশন দিয়ে গেছে। একটু হিসেবে ট্রিট করেছি।
হয়তো দীপঙ্করে পেয়ে আছে। একটু দীপঙ্করে পেয়ে আছে।
এটা বহুত কিছু নিতে করছি।
এটা মোট
কত পাইছিল আপনাকে ফার্স্ট টাইম শুনছি।
28 নম্বর। এটা ভালো করতে পারে। এবার না বাস্তব। Yes. Esto থাকিলে মোক আনদিন ফোন কৰিবা হা। সেইটো অলপ প্ৰিপেয়াৰ হ'ব লাগিব। আজি মই ফটো আহিলে মই ধৰিব পৰা নাই। GD entry and status report present status, right? Become from verified. You are one maro. It is to become correct. Yeah, I will like it. I'm not telling again. That's one voice.
More than
Karim, Silcher.
We are also directing
Yes, Lord.
the establishment of the Director General of Police to trace out this respondent number 6 and provide this person with a downloaded copy of this order to respond by the next week, by the next date of listing. Wherever he is posted, they will try to find out and
Where is Sikkim, madam?
Hmm?
Sikkim.
Wherever he is,
yes.
wherever this person's respondent number 6 is, the deputy DIG for the the Director General of Police will know their establishment. They will find out and serve a download copy of this order. We don't need amendment of the cost title and all. The service on respondent number 6 is not complete.
Milord, 25/1/2019, it is complete, Milord. As per office note, Milord, 25 January 2019, Milord.
Respondent 6.
Then, Milord, this honorable court saw the present status of the respondent 6 on 14 and 23. Accordingly, they have submitted the fresh, his present address, Milord. And at this case, Milord, perhaps he posted some another.
So, but
Yes.
he's it's already served. If he's not appearing, it is at his risk.
Yes, Milord.
Notice is already served.
Yes, Milord.
Court has drawn a presumption.
Yes, Milord.
Heard Mr. P. K. Degal and counsel for the petitioner, as well as Mr. P. Sharma and an additional senior government advocate. Next, this. By filing this writ petition on 27/7/2015. The petitioner has projected that on 7/7/2012 at about 12:30 a.m. within bracket intervening night of 6/7/2012 and 7/7/2012, the police personnel led by the respondent number 6 had taken into custody one Azizur, Azizur, Rahman, the father of the petitioner. So it is projected that due to physical torture, he died on the same night. Full stop. The next part, the learned counsel for the petitioner, by referring to the affidavit and documents annexed to this, on record, has submitted that the witnesses deposed during inquiry that the respondent number 6 had twisted the head and neck of the deceased, after which he collapsed and thereafter died. Just wait. This man, was he alive when he went to the hospital or not?
But already, while before reaching the hospital, he died, my lord. We have another document we have enclosed in, my lord.
Where is that?
My lord, in the same additional affidavit, my lord, Annexure A, page 109, my lord.
109.
Yes, my lord. It is first report, my lord. There is 194 page, my lord. It is recorded. It is brought that. Subsequently,
109.
it is
This page numbering you have done
in my inner space. my
one
lord.
after one on top of the other. We can't locate this page. Page 109.
Annexure A, my lord. Though it is written 45, but subsequently it is 109. In my additional affidavit, my lord.
Yes, 109. Yes.
My lord, also we find the serial number 194, the right, very left side, my lord. It is initially written that Azizur Rahman brought that, my lord. Subsequently, it is, my lord.
194.
Yes, my left side, my lord. Left side, my lord. My lord, it is, my lord. 194 serial number. In the
194 is deleted.
Yes, deleted, my lord. This is such a question, my lord. Initially written, it's a broad test. Subsequently, this report. This is also ground we have taken in this matter.
Okay, then.
And then, my lord. Yes, my lord. It is said that, my lord, the findings reported that BP not recoverable, and ultimately they forwarded him to the Silchar Medical College Hospital. And Silchar Medical has found that he has brought death, my lord.
Where is that finding brought dead? Where is that?
Yes, my lord. Yes. My lord, in a magistrate inquiry, my lord, the concerned doctor's evidence recorded at page 16, my lord. In the same affidavit, kindly have a look, page 116. It is Somik Bhomik, Dr. Somik Bhomik.
116.
Yes, my lord. Evidence, witness number 7. Sorry, 116.
Yes.
Witness number 7. May I read this evidence on part, my lord?
Just that part.
He found Azizur, sorry. He found Azizur grasping. The pulse was feeble. The BP not recoverable. He observed the patient and gave the injection Dexona. He tried to improve the condition of the patient. He noticed that condition of the patient is serious. Without wasting any time, referred the patient to the Silchar Medical Hospital. And Kasat, the YT gastro, that is the response 6, and others accompanied the patient. When he was asked for the comment that there is some deletion of the writing, that is, my lord, there is a deletion in the writing above the report of the Azizur Rahman in page number 194 of the register. He said that he has no idea why there is deletion. He has not seen sign of external injury on the person of Azizur Rahman. No family members of the patient accompanied to hospital. There is an ambulance service in the hospital. At that time, oxygen was not available in the ambulance, my lord. and there was no time to wait and call for an ambulance having oxygen facility. By vehicle of the police of Kaline, the patient was sent to the Kaline to Silchar Medical Hospital, and during his duty period of 11:50 a.m., he examined one Kartik Re as patient whose number entry made. He has not taken any steps to find out who deleted the portion of the entry made above the entry 194. Next, my lord. Another doctor is on আছে ইয়াতে আছে
SGM Silchar Medical Store issued new report.
100% আছে তো বদল কনস্টেবল শ্যামল চক্রবর্তী When that ambulance, oxygen was not available. No family members accompanied. That's it. Additional affidavit that এটাই করছি রেসপন্ডেন্ট 1 দিয়া রেসপন্ডেন্ট 1
The investigation is pending in which matter? Case number? Just tell us the case number.
Respondent 1. Respondent 1.
Just write the order. Certificate of council registration. So next page. Already said one part referring to the documents. Stop. By
My lord,
further, by
it
further
has-
referring to the documents available on record, it is projected that as per the entry made in the hospital register of this is CSC Kaline of CSC Kaline, comma the deceased was shown to be brought dead. First off, however, there is an erasure of that entry, and in the subsequent entry, the disease was shown to be alive and projected to have collapsed during treatment after he could not be revived. Next part, it is further submitted that as per instructions available with him, comma, the investigation of, yes, case number?
My lord, in 85, my lord, Respondent 1 affidavit file, it is there, my lord. It is
Just tell us the number. If we have to read it, then we will not require your assistance.
FR number is here, my lord, only. Initially, the final
Oh,
report.
no, there are some documents. You see, I read so fast, I will not be able to recollect where I read it. Initially, an FR was given. After that, it was reinvestigation was ordered. In one of the documents, a reinvestigation is ordered.
Yes, my lord.
We just want the case number.
Yes, my lord. Case number 1 number, case number 20, Silchar case number 20. Silchar case number 2. Yes, number 2. But the Kathigura PS case number 291 of 2012.
Category PS case number
Of 291 of 2012.
is stated to be still pending for investigation. After reinvestigation was ordered in the matter. Next para, accordingly, the learned senior government advocate, additional senior government advocate shall communicate to the officer in charge of Katigura police station to direct the IO of Katigura PS case number so and so to send the original case diary to the court. Full stop. The order to call for the records of the said case shall be communicated to the officer in charge of Katigura Police Station with copy thereof to the Superintendent of Police, Kachar. This will be Kachar.
Kasar, my lord.
Kachar. So as to enable the said authority to follow up the matter. Next paragraph. While sending the case diary, the IO shall also send a status report of investigation. Just need to ऊपर जाओ. Next paragraph. So, produce the case diary. Communication to that effect can also be sent through the VHF facility installed in the court or by email, as maybe as may be convenient to him. Next para, list on, give a date after 2 weeks.
And my lord, respondent number 6, my lord, whether it is any direction to DGP, my lord, to, yes,
No, it's not required. Once service is made, service is made.
yes, my lord.
If you want a service, then if you want a delay in the matter,
No.
then we
No, my lord.
issue notice.
No, my lord. You play, bless, my lord.
Upgraded item 27 for admission.
Please, Your Lordship. This is the second round of litigation. Your Lordship, earlier it was remanded back to the tribunal and order of this annual court. Your Lordship, find page 61. But again, he was declared as foreigner. Page 61. We start from page 61.
What is the best document to connect you to your registered parents?
That is next kin document, Your Lordship, page 47. Next of kin certificate, page 67, 47. It was proof here.
Date of death is 1992. You have the death was registered in 2017. Where is the ministerial order to have the death registered?
I found that the report is, inquiry report is there, page 46 on the Ratmund order.
No, you see, these are post-inquiry documents. This is a matter which was referred to IMDT in 98. After 98, that means the death was before that. After reference, after the matter was remanded. The order dated 26/8/2019.
Lordship. Relevant portion, your lordship, page 63 of this. 66 is for the your lordship. In view of the above, we set aside the improved opinion with direction that petition appear to so and so and so.
So now that was considered and rejected.
The tribunal shall hear then conclude the case within a word so and so and so. Only exhibit I documents, rendering fresh opinion only on the matters already available on record. More particularly in respect to exhibit I document. And again, impugn order, start from.
Is there a land in the name of your father?
Land is father. Yeah, revenue
Have
receipt,
you-
page, I have find page 38,
38.
page revenue receipt.
No, no, revenue receipt would not do. If you have a land, it can be demonstrated that you have a land, your father had a land. You see, next of kin certificate is issued by the revenue authorities only in case of debts and securities not exceeding rupees 2,500.
And document is page, your lordship, 40. Shall deed.
Today, if A dies, without showing the ownership of land, allotment will not be able to give a certificate. That certificate itself, if you go to the root of it, you'll have to demonstrate that the next of kin certificate can otherwise be granted, not being issued for debts and securities not exceeding rupees 2,500 as per the revenue circular.
And document is exhibited, it's exhibit F is shell deed of 1979. Page 40, 41 is the original.
Where is your written statement?
Written statement, your lordship, page 49.
49.
49. So next in paragraph 16.
there is an issue you'll have to come prepared. Number one, the land which you are showing and appended to this writ petition was purportedly purchased in 1979, which is a document of post 25/3/71. That's number one. Number two, you are showing us revenue paying receipt. It's of 66. Now, this is an interesting document. The reason is that this receipt is issued by the landlord. It's not by revenue authorities. That is page 39. It's a document which is not issued by the land revenue authorities. It is issued by the landlord. Correct? And it is given for the wholly of that land. Whether the wholly is a tenant, we don't know. And once it is given by a landlord for the wholly, then this would be a receipt which is deemed to have been issued by the erstwhile Jamindar under the Gwalpara Tenancy Act. Now again, there is a small turn. Assam State Jamindari Abolition Act came in 1951. So once the state government takes over all the estates under the erstwhile Gwalpara, this is Dhubri. Dhubri was earlier Gwalpara. Once that has been taken over, then you have to show that in 1966, the money paid was a bona fide payment. Therefore, unless that is established, the stay of before 1971 goes.
This is there, 66.
No, that's okay. You are saying that Jalia so-and-so is your father. That is required to be demonstrated by virtue of a document. Then again comes your birth certificate, death certificate of your father. That is registered after a lot of years. 22 registration is made in, what we said, I forgot, 2017 or 18, it was registered. So you have to show that a magisterial order was there. You are under the Births and Deaths Registration Act. There's a requirement to have a magisterial order. Then the other aspect we have already told you. That is that the next of kin. So a lot of answers you have to give. You want to do it today or some other day? Also as a representative on the prayer made by the Land Council for the petitioner, list the matter after 2 weeks. There was a request for upgradation of a matter. Which matter is that?
44 or 45. There's my matter. I'm waiting since morning.
44, what is that? Show it to us.
Restoration petition, Lordship.
Hmm?
Restoration petition, Lordship. Dismissed for non-prosecution.
Your Lordship, order page 10, my lord, the petition was dismissed for non-prosecution. On 34/2025, my lord. The case has been dismissed for non-prosecution. But I have filed this restoration petition, but you have told the same, my lord.
Okay, we allow it. This dismissed on 30. He is filed this application on 8th.
Yes, Lord. The record is not yet sent back.
Okay.
Record is not yet sent back, Lordship.
Huh.
Thought that may be fees for hearing, Lord.
Okay. heard Mr. H.R. Khanda and counsel for the petitioner. Applicant? This will be petitioner. All the respondents are there. By filing this miscellaneous case, the petitioner is praying for restoration of the WPC 642 of 2017, which were dismissed for non-prosecution on 30/4/2025. Next, by the Learned Counsel for the petitioner submits that on the said date, he was out of
Correct,
session and could
three
not
Lord,
appear
right, yeah.
before the court. And on coming to know about the dismissal, he has filed this application on 8/5/2025. Next paragraph. Having regard to the although the learned standing counsel for the FT matters has opposed the application, but considering that the matter was dismissed for non-prosecution on 30/4/2025, and this application has been filed on 8/5/2025. The explanation of the learned counsel for the petitioner is accepted as a good cause for not being able to represent the petitioner when the matter was previously listed on 34/2025. Next one. The application stands out. We are making this application stands out. The connected WBC 642 of 2017 is restored to file in the main writ petition.
Along with the case record.
In view of the order passed today, the order dated so and so is recalled, 34/2025 is recalled, and the matters restored to file. Okay.
Item number 36, Lordship, probably your Lordship are taking up a PSC matter in second half. This matter may not reach Lordship, and in this case, last order, your Lordship passed that if hearing does not take place, your Lordship will consider the application for bail. So that's the interim prayer. So
Okay, but since we are not taking,
may I
it-
pay for a date, Lordship, next week, Monday or Tuesday, Lordship,
not Tuesday, again, same thing will happen.
Uh,
Let it be a miscellaneous day.
Lordship. All right.
May I please, listen, item 23, my lord, may be upgraded,
Item
23.
Item 23, no. We are in the midst of a parted hearing on those bunch of matters. This matters will go to some other day.
Obligation. May I please, Lordship, my lord, yesterday I have submitted my lord.
Just a moment.
Sorry.
Yes.
Yesterday I have already submitted that, my lord, one Srimati Sanjana Fukan and Sanjan Fukan and Abhilasha Borua,
Yes.
Obisika Borua. All they are declared as an approver by the my lord prosecution, and in respect of my lord service, my lord, this matter, my lord, the Obisika Borua and Sanjana Fukan, they have initiated, my lord, they has already suspended from the service, and they have started departmental proceeding, my lord. To that aspect, my lord, in our my lord, affidavit in reply, we have stated, my lord, paragraph this,
We take your word for it.
my lord, yes. That is in the pleading, my lord, I want to show, my lord. And in respect of that, my lord, in repeal case,
These three people,
yes, my lord,
the petitioners here,
yes,
the petitioners here,
yes, my lord.
they were suspended
They were suspended because they were arrested, my lord.
They were arrested.
As police
And the
custody.
approvers, those were departmentally proceeded with.
They have suspended and pending departmental proceeding, they are suspended from their service, madam.
Okay.
That is my
That you
submission.
have already submitted yesterday.
Yes, to submitted, my lord, I want to show in my, yes, my
No, it's
lord.
okay, we will accept your
Yes, yes, yes,
statement.
my lord. And my lord, in writ appeal also, we have taken this point, my lord.
We are, Mr. Chaudhary, we are not questioning your credibility.
Yes, yes, my lord.
Correct. You don't come into that bracket.
No. And my lord, in this, then I am directly go to this husband, my lord. Writ appeal paragraph 10, I also mentioned, my lord. Yesterday, I am in the midst of Ratnesh Chaudhary case, my lord. Citation is, my lord, 2015 SSC 151.
Let's see. Notes.
I have given book list yesterday.
Kali.
The facts of the Ratnesh.
15 SCC 151. You did not give us the paragraphs.
Yes, my lord. I read the paragraph. I read the নতুন তো বনাস আছে। Paragraph is, my lord. T. 15 to, my lord, 28, my lord.
Yes.
I have prepared, my lord. Load, my lord. File by 2 লিখে দিন। I have prepared, my lord, written argument, man. দুইটা কপি দিতে। Podcast file by 2 লেখনা। In Ratnesh Chaudhary case, my lord, it was categorically stated that interviews has been taken place for the post of, my lord, SES therapist, and he was applied for this my lord, psychotherapy, my lord. What happened, my lord? Ultimately, he was appointed as a SES therapist, my lord. Subsequently, a minister has submitted a complaint, my lord. On the basis of that complaint, my lord, a vigilance inquiry took place, my lord. On that vigilance inquiry, my lord, she found, my lord, there is a, my lord, some, my lord, misnomer took place. That is why he was terminated from the service, my lord. Ultimately, my lord, last of the paragraph has categorically stated, as because this is the foundation, vigilance report, my lord. It is not the motive, my lord. So, there must be, my lord, opportunities should be given for submitting, my lord, reply. Accordingly, termination order has been set aside, my lord, and they were reinstated in their service. And this case, my lord, before appointment, this thing has been happened, my lord. This is the case, my lord, only case I found, my lord, where pre-recruitment and post-recruitment has been mentioned. Pre-recruitment has been mentioned. Other cases, my lord, they are not distinguished in respect of post-recruitment and pre-recruitment, my lord. Then, my lord, another case is that, my lord. Rajendra Yadav, my lord. 2013, 3 SSC 73, my lord. Your lordship will find, my lord, serial number 4. Case law referred and rely upon. Have a lordship got it?
Yes. Rajendra Yadav.
Yes, my lord, serial number 4. In that, my lord, case has categorically stated, if the, my lord, allegation is identical, then, my lord, the parity shall be maintained, my lord. I want to show some paragraph, my lord. Era 8, my lord. This is very short judgment.
This is there in the,
Yes,
in
ma'am.
this write-up, it is there.
Yes, yes.
Yes, ma'am.
We don't need this.
Yes, ma'am. Parity shall be maintained.
Yes.
Then, my lord, to same footing, my lord, there's another judgment, my lord. That judgment is, my lord, is D.B. Beliappa, my lord. In that also, my lord, citation is, my lord, 1979, 1 SSC 477, my lord. There has categorically stated that, my lord, similar persons should give equal opportunities. This judgment I specifically taken because this Abhisika Borua and Sanjana Phukon and, my lord, petitioner are in the same footing, my lord. And that is why in that case, my lord, what happened, my lord? Some person has been given, my lord, opportunity, my lord, and some person will not given the opportunity. That discriminatory treatment has been given by the, my lord, respondent appointing authority in particular case. The Honorable Apex Court has said that this is violation of Article 14 and 16 of the Constitution of India, my lord. And in respect of dismissal, equal treatment should be given, my lord. That is also there, my lord.
Yes.
And, my lord, the paragraph which I relied, my lord, has been mentioned in that.
Yes, 18 to 26.
Yes, my lord.
18, 19, 20, 23.
Yes, my
22,
lord. Yes, my lord.
26. No.
And so far, relating to one, my lord, latest judgment I found, my lord, Sarita Chaudhary. One of the citation is 2025, my lord, SCC Online SC 459. Here, my lord, fact of the case is that, my lord, there are 6 district judges, my lord, learned district judges of Punjab. There is a complaint filed against them, my lord. 4 has been, my lord, given discharge from, sorry, my lord. 4 person has not taken any action, my lord. So far, relating 2 person is concerned, matter has been referred to the full bench, my lord, of the Punjab. Full court. Punjab Haryana, sir, no? Sorry, Madhya Pradesh, my lord. Full court to the Honorable Honorable Madhya Pradesh High Court. In that, what happened, my lord? On the basis of, my lord, report submitted by the authority, my lord, they were, my lord, discharged from the service. Ultimately, these 2, my lord, district judges moved before the Apex Court, my lord. Apex was categorically stated, my lord, if the report which has been submitted, just like a police report, is the foundation, then you have to give, my lord, opportunity of, my lord, hearing. They have to face the judge. Their paragraph I has mentioned, my lord.
Yes, we'll read that part, 2025.
Yes, well, I am reading, my lord.
20,
2025 SSC Online SC 459. In note, my lord, I have mentioned, my lord,
You've seen it, number 2.
number 2.
Just read that operative part.
Yes, my lord. Not to kindly come to the para 12. May I read, my lord. Para 12. I am reading slowly, my lord.
Yes.
The service of probation
No,
are
SCC Online will be down. SCC Online. No, down below. More down.
Lordship, I'll just assist him.
No, nalang hai.
Sarita Chaudhary.
Yes, my lord.
Just find by nominal way. Nominal search. Do a nominal search. No, it's okay. We have got it. It's okay.
Yes.
Paragraph.
Para 12, discussion. The service of a no, yes, I said so. Yes, ma'am. Discuss of para 12, man.
Yes.
The service of a professional could
This token.
the service of a professional could result either in a confirmation in the post ended by way of termination simpliciter. However, if a professional is terminated from service owing to misconduct as a punishment, the termination would cause a stigma on him. If a professional is unsuitable for a job, has been terminated, then such a case is non-stigmatic and it is termination simpliciter. Thus, the performance of a professional has to be considered in order to ascertain whether it has been satisfactory or unsatisfactory. In respect of our case, performance is not the criteria, my lord. No right of hearing also reserved with the professional. Hence, there would be no violation of principle of natural justice. Then reiterate the Purushottam Lal Dhingra, my lord. I am reiterate, my lord, that part I skip, my lord. Or I read, my lord.
No, not required.
Because, my lord, that has already. One important, my lord, para 13, my lord. Anup Joswal. Para 13(1), my lord. The fact that impugn order of discharge was passed in the middle of the probation period after seeking an explanation regarding the LS Act of indiscipline. Similar explanation were called from the person other than the appellant therein. But the end of only the case of appellant was dealt with severely. This court observed that even though the order of discharge was non-committal, it could not stand alone. It was observed that though the noting in the file of the government may have been irrelevant, the cause of the order of discharge could not have been ignored. That the recommendation which is basis of the foundation for the order of discharge in noting file, in respect of our case, there is a noting, my lord, on the basis that a confessional statement is available. Chief Minister noting, Advocate General opinion is also there, my lord. Law Department opinion, my lord, should have been read with the order of the purpose of determining the true character. If on reading the two together, the court reached to the conclusion that alleged act of misconduct was the cause of the order, but for that allegation it could not have been passed, then it is inevitable that order of discharge should fall to the ground. This was because the appellant therein had not been afforded reasonable opportunity to defend himself as provided Article 311(2) of the Constitution of India. By holding so, this court held in paragraph 12 as under. It is therefore now well settled there, where the form of the order is merely a camouflage for an order of dismissal for misconduct. It is always open to the court before which the order is challenged to go behind the form and ascertain the true character of the order, my lord. Leave the veil, my lord, and look all these things, my lord. If the court hold that the order true, the form is merely determination of employment is reality, a cloak for the order of punishment. The court would not be debarred merely because of the form in the order in giving effect to the right conferred upon the employee. Consequently, in the aforesaid case, after discussing the fair detail, this court set aside the order of discharge termination, ground that the injury ought to have been held against the appellant with prior termination of service. As a result, the appellant therein was reinstated in the service same rank, seniority he was entitled to the order discharge passed. And then, my lord, Dipti Prakash Banerjee, my lord. Next para, sub-para 2, my lord. 13.2, my lord. 3 point has been formulated, my lord. The point is, on what circumstances termination of a probation service can be said founded on misconduct, and what circumstances could be said the allegation of only a motive. When can, next, my lord, when can order of termination of probation to be said to be certain and express stigma? Can stigma be gathered by referring back to the proceeding referred to termination order? Each of the aforesaid points were answered, which can be summarized as under. If the finding were arrived at in an inquiry as to misconduct behind the back of the officer without the regular departmental inquiry, simple order of termination is to be found is to be treated founded on the allegation, and it will be bad, my lord. Same thing in my case has been happened, my lord. But if the inquiry was not held, no finding were arrived, and employer was not inclined to conduct an inquiry, but at the same time, he did not want to continue the employer against, that is not important. Point 2. There is a considerable difficulty in finding out whether in a given case, where the order of termination is not simple order of termination, the word used order can be said to contain a stigma. It depends upon the facts and circumstances of each case, language, word used to ascertain whether termination order contains stigma. Next, material which amount to stigma need not be contained in a termination order of the probationer, but might be contained in the document referred to in the termination order or it annexes. Same thing, my lord. This is the basis of the police report, my lord. So my humble submission before your lordship is that, my lord, if the authority, my lord, has, there is a simple order has been under 20C, you are discharged from the service, my lord. But when the affidavit and other has been filed, they have categorically stated, and it was also discussed, police report has been discussed in the order. On the basis of police report, this, there is some, my lord, adverse comments against the petitioner, so you are discharged from the service. Moment they said all these things, my lord, I am entitled for the, my lord, giving reply, my lord, and protection under Article 311 should be given to me. And the in the single just order it was mentioned, there is some opinion of the, my lord, judicial officer and, my lord, and other advocate general and other. If that is so, my lord, all things has been done behind the back of the petitioner, my lord. We do not know anything, my lord. So we are entitled for all the document, my lord, and give our reply, my lord. There are simple. Then, my lord, it is true that Supreme Court in some cases held that termination is punitive where the employment has been suitable, writing advice. However, in all such cases, there are simple order termination did not contain any word amounting to stigma. However, on the other hand, there is a stigma in the impugn order which cannot be ignored because it will have to affect the appellant future. Stigma need not contain in termination order. Have you also got it, my lord? Just thereafter, my lord. Point 2, cross thereafter, my lord. Stigma need not contain in termination order, but may also contain in the order of proceeding referred to in termination order, annexed there to vitiated the termination order, my lord. After cross that paragraph, my lord. That is important, my lord. Indropal Gupta, Managing Committee Model Internet 1984 TSSC 384, it was observed in paragraph 35 that the said decision is clear authority for the proposition that the material which amount to stigma need not be contained in the order of termination of probationer, but might be contained in any document referred to termination order in its annexure. Obviously, such a document could be asked for, call for any future employer, or in such cases, the order of termination would stand vitiated on the ground that no regular inquiry was conducted. Ultimately, my lord, last paragraph, what is it? Ultimately, your lordship will come to the page, my lord, paragraph number 16, page, my lord, 54. On perusal of the minutes of the Administrative Committee High Court 8-5 to 10-5, it is apparent that committee considered ACR assessment service include complaint pending concluded against the two judicial officers. Their consistent poor performance work done, other material also considered committee. As a result of second, it was resolved the entire two officers were no longer required to continue their post. The minute of the exposed. My lord, come to the para number 3, my lord, sub para 3, my lord. As far as other material, have a look at it. As far as other material considered is concerned, it could have been
Reading which paragraph?
16.3, my lord. That's sub para, my lord, Roman 3.
As far as other materials considered.
Yes,
Oh,
my
yes.
lord.
Yes.
As far as other ministerial considered, it could have been complaint which were either concluded or pending against them. If the complaint from the foundation of this officer to be terminated, we find that voluminous cases which we have referred the above, and clearly point out that opportunity had been given before termination. Opportunity had been given before. This is the particularly having regard Article 311 Constitution related to relevant conduct rule. That, my lord, Rule 64, 1964, if they consider this police report as a foundation, my lord, they want to say that this police report is the motive, not the foundation. They cannot take as a motive, my lord, because there are such stigmatic view, my lord. It is a foundation, my lord. If that is so, my lord, then, my lord, 311 protection should be given. Therefore, in our view, termination of two judicial is punitive, arbitrary, therefore illegal. They are not in accordance judgment of this court discussed above, as we applied. Next, my lord, para 6. Therefore, we are viewed the impune termination herein by way of punishment among surrounding circumstances. Also, that termination were entirely founded the allegation, complaint of misconduct and inefficiency were stigmatic in nature. Para 6, my lord, Roman 6. Next page. 13, Roman 6, my lord. Even though many the complaint against this official may have been closed or resulted advisory warning, they could not be the basis of impune termination. My lord. And, my lord, so far, my lord, there are other judgments also, some. Another one is, my lord, that Manaka Gandhi judgment, my lord. It is a voluminous judgment, my lord. I am not reading this judgment, my lord. The Honorable Single Judge has said this case, if the case all, Manaka Gandhi 3 exceptions. Promptitude,
Need for urgency.
need for urgency, and
If it has an effect on paralyzing the administration.
if there is an effect of paralyzing the government, my lord. To that effect, my lord, they have to give, my lord, some, my lord, indication in the order. In that order, my lord, nothing has been stated. Just like NSA case, your lordship, your detention is necessary for the prejudicial to the activities of the state. That line should be there, my lord. Nothing is there. And interesting, I found this Honorable Single Judge, my lord, in one paragraph, there is a 18 days hearing has been given, my lord. So, Honorable Single Judge has said, my lord, that it is a audio term partem, Manaka Gandhi has been fulfilled. My lord, in 220 judicial review of the administrative action, my lord. And it is the appointing authority who should be heard, my lord. And thereafter they pass an order. That was not done. If, my lord, Single Judge, my lord, hearing, 18 and hearing, it will not come, my lord, that this order is, my lord, good, my lord. It is para 53 of the impugn judgment, page, my lord, 747. I read slowly, my lord, the particular. On the argument, page 747, my lord, second volume, no? Second volume, my lord. I am reading, my lord. On the argument, if protection under Article 311 is not applicable, the ideal term patent rule sufficiently flexible to permit brief and minimal hearing following Manaka and this court observed that if an extreme view is taken that petitioner could make out the case they have suffered a prejudice on being denied of opportunity of hearing, then same would be no bearing. This court would record and petitioner would admit that opportunity of hearing was granted ample measure by this court during the course of hearing day-to-day basis, covering 18 days. Both sides were heard. Their contention and argument extensively and elaborately, both as on facts as well as law, my lord. That hearing, my lord, cannot come, my lord, because the order has been passed, my lord, termination order. Before that, the hearing should take place, my lord. This is the order on, my lord. Well, one important, my lord, just last judgment, my lord. Yes, yes. Yes, yes, sir. Last judgment of my written argument, my lord. 7, my last page. 2022 12 SSC 200, my lord. In para 27, my lord, the search sheet is mere opinion of the investigating officer, the truth of which can only be decided by a competent. Search sheet, this is nothing but an opinion of the investigating officer. That truth can be decided in a competent court, my lord. And this was not done in the instant case. Even I have already submitted 161 statement. So far petitioner is concerned, name was not taken. Approval also not taken the name of the petitioner. No one has taken the name of the petitioner, except this they have stated that their confessional statement that is not available in the, my lord, criminal matter, because document has already been served. In that document is not available, my lord. That is my humble submission before you, my lord. If anything is submitted, my lord, against me by the, my lord, respondent authority, I shall give reply. And I have given already a written argument, preliminary written argument. Written submission, my lord. Subsequently, if necessary, I shall give much obligement. My part is complete.
Yes, Mr. Chaudhary, you will be.
Yes, I would like to argue, my lords, ideally, physically, my lords, if your lordships could give me my turn on Monday, because there was some confusion, my lords. Mr. Das was arguing and he stopped now. Mr. D.K. Misra was supposed to argue before me, my lords. Now I'm told he wants to start on Tuesday. The lordships want, otherwise I can start today virtually, my lords.
No, you can do it because we have our limitations. We have to wind up in.
I understand that, my lord. The lordships have been very patiently hearing it.
Otherwise, we'll not be able to complete, and then we'll have to leave it midway.
Yeah.
That is the.
No.
Don't want to do it.
That would be a colossal waste of judicial time, my lord. The lordships have been hearing this matter first very patiently, my lord.
We have our limitations.
I understand that the time is running out, my lord. I understand that. Tremendous pressure, my lord. I understand. And it's a very humongous matter, my lord. I can otherwise, my lord, start today, give your lordships
yes.
round of the case, my lord.
Please.
And then, my lord, I will come on Monday, my lord. My one request would be, can your lordships also accommodate me in the first half on Monday, my lord? Subject to your lordships' convenience. Otherwise, my lord, I will start on Monday at 2 o'clock. But if your lordships can also accommodate me in the first half.
Because we have a bench of foreigners tribunals where also.
That's okay, my lords. Then Monday also I'll continue, my lord.
You have to consider prayers for bail.
Understand that. That's fine, my lord. I will not push it. But my lords, I appear, my lords, in writ appeal number 14 of 2022, my lords.
Writ appeal number?
14 of 2022.
That is today's item number?
88. 88.
88.
I'm grateful, my lords. to my lord. My lords, the appellant is Suranjita Hajarika, my lords. She was appointed, my lords, as a district transport officer. Pursuant, my lords, to the competitive examination held for the year 2014. Prior thereto, my lords, she was a banker, my lords. She was an assistant manager, my lords, in Hong Kong and Shanghai Banking Corporation, my lords. She gave up that job to join the services, my lords, like all middle class families, my lords. They intend that the children join the civil service. Otherwise, a good career. Till, my lords, she joined as a probationer. I'll come to the list of days, but I'm just giving a flavor of my client's appeal I'm arguing, my lords. She joined as a probationer, my lords. She underwent the training. No adverse reports. Till, my lords, she was discharged by the competent authority, my lords, by the order of 21/1/19. I'll place that discharge order, my lords. No hearing was given, my lords. Admitted position. No notice, no opportunity of hearing. So the discharge order, my lords, is a unilateral ex parte order, which your lordship has been called upon to examine, my lords. So, my lords, my writ petition was filed even prior to the discharge order, where, my lords, a declaration was sought that she still continues to be an active member of the service. An apprehension, my lords, was voiced on the day when the matter came up for motion, my lords, before this court. And Justice Koteswar Singh, my lords, as his lordships then was, made an observation in the order issuing notice that it goes without saying that the authority will have to abide by the law before discharging any person from service and subsistence allowance. I'll place that order, my lords. And immediately thereafter, my lords, when that order is served, my lords, on the department, the discharge order is passed. The discharge order, my lords, I'll place the discharge order. The discharge order, my lords, is in exercise of powers under Rule 19. I will place that rule, my lords, of the Assam Transport Service Rules, 2003. And, my lords, the contention of the department is, my lords, that Rule 19 does not visualize any kind of hearing. That Rule 19 is silent. It is not only silent, it excludes any opportunity of hearing to an officer before that officer is discharged from service. Something, my lords, your lordships will have to test it, my lords, in today's day. My lords, for the government to say that we are exercising absolute power of discharging a person, an officer, with a stigmatic and punitive order, my lords, I'll place that order. Now, my lords, when the matter is finally heard before the single judge, my lords, I'm just giving a lordship the flavor. The single judge starts the hearing. And prior thereto, my lords, there are two affidavit in oppositions which are filed, my lords, by the state. The first affidavit in opposition which is filed, my lords, in my client's case, my lords, is of 8/5/2019, my lords, 8 May 2019, where their stand was, my lords, that we have proceeded on the records. The foundation was the Dibrugarh police station case, on the basis of which the discharge order has been passed. It says that we acted on certain unverified information which we received. and by virtue of which we conducted a verification and then issued the order. Now, my lords, now, when the matter, my lords, comes up for hearing before the single judge, Justice Koteswar Singh, my lord, the matter was fixed for hearing. A request is made by the state on 18/6/2019, my lords, to file certain additional documents. So Mr. K.N. Chaudhary, my lord, the learned senior advocate appearing, tells the court that the matter is listed for hearing. In case your lordship is adjourning, that grant us interim orders. Justice Singh, my lords, grants them time to file documents and observes that if for any case event the matter is not heard on the next returnable date, the discharge order stands stayed against all the petitioners. Now, my lords, thereafter, an additional affidavit in opposition is filed. Your lordships have seen that affidavit. Now, this additional affidavit, my lords, brings in startling revelations for the first time. It is, my lords, a tectonic shift in the stand of the state. A shift which I will, my lords, demonstrate to your lordships is impermissible. They cannot, my lords, it's not a game of chess. That today they will take one stand, tomorrow they will make a stand, my lords. They will, my lords, be held to the pleadings which they have made before the court. They have not applied for any leave or permission to file an additional document, additional affidavit. There is no permission granted by the court to take that additional affidavit on record. And yet, the single judge, my lords, with respect, my lords, has relied upon this additional affidavit. And this is the sole ground, my lords, on the basis of which the writ petitioners have been non-suited by the court. Not only that, my lords, in that additional affidavit, my lords, something, my lords, very serious is stated. They say that my client, my lords, who I represent, the appellant herein, paid a bribe, my lords, of 45 lakhs to secure her appointment. There is no confession statement placed on record. There is no disclosure statement of the accused placed on record. And such confessions, if any, my lords, is hit, my lords, by the Indian Evidence Act. Section 25, there is a clear bar, my lords, in case, my lords, otherwise, my lords, the lordships knows how police acts, my lords. They will have all kinds of confession, my lords, from the accused when they are in custody. My instructions are, my lords, when she was arrested, not even one statement was recorded from her. The investigating officer did not even meet her. The arrest was made, my lords, in the normal usual course. And then, my lords, a disclosure is made, my lords. I have something to say on this, my lords, because an affidavit filed before the court, my lords, has some sanctity. A disclosure is made, my lords, highlighting that a bribe was paid, my lords, by my client to secure her appointment in the job. And the learned single judge, my lords, with due respect, my lords, faltered in relying upon that statement. And in two places, my lords, in the impugned order, records that huge amount of bribe was paid to secure employment. Now, my lords, till today, we have not seen any such disclosure statement. My client now, my lords, who was charge sheeted, appeared before the special judge, is appearing before the special judge. The records under 207 has been furnished. There is no, my lords, no disclosure statement. There is no confession statement forming part of the records. Even, my lords, the charge sheet which is on record, my lords, it's part of the appeal paper book, my lords, place it. There is not even a whisper of an allegation that the appellant either, my lords, because it's not even a case of attempt. It's a case, my lord, that the appellant actually bribed to secure employment. There is not even a whisper of that allegation. Now, my lord, what happens is this, my lord. Now, the single judge, my lord, takes the additional affidavit. Along with the additional affidavit, my lord, something more serious. are seal cover documents which are supplied to the learned single judge. We don't know what are the contents of the seal cover. And those seal cover documents are relied upon extensively and findings rendered by the single judge in the impugned order. So I'll make good my submission that principles of natural justice here, my lords, has been violated at two stages, my lords, with due respect. One, my lords, when the administrative authority passed the order without granting me any hearing, no notice, nothing. And second is, my lords, the manner of adjudication by the learned single judge, my lords. The learned single judge ought not to have relied upon seal cover documents in a matter like this and arrive at findings and render findings against the writ petitioners based on seal cover records. I will make good my submission, my lord, that reliance on seal cover documents, my lords, should be avoided. That's the latest trend, my lords. And it only furthers opacity, my lords. Now, my lords, the single judge, my lords, as my learned friend, Mr. N.N.B. Chaudhary, ended by saying, my lords, says that fine, the administrative authority did not grant you a hearing. I have patiently heard this matter for 18 days. I have allowed all contentions to be argued before me. In a way, my lords, the single judge, my lords, has given the impression, my lords, in the impugned judgment that even if there was no hearing given by the original authority, we have given a hearing. So this hearing is a substitute, my lords, for the hearing which would have been given by the original authority. If that is the case, my lord, my respectful submission is, my lord, it will lead to dangerous consequences. All authorities tomorrow, my lords, are going to say that we are not giving you a hearing, you will get a hearing before the High Court. Go and take the hearing before the High Court. Can it be done, my lords? Can the High Court, my lords, substitute itself to the authority who has to take a decision? In judicial review, what your lordships will do is, your lordships will look into the decision-making process, look into the procedure followed by the authority. And if your lordship finds, my lord, that there is no compliance of principles of natural justice, or that the order by itself is arbitrary, my lords, your lordships will set aside the order instead of stating that I have gone through the records, I've given a hearing, I've given patient hearing running into 18 days, and that itself is a substitute, my lords, for the hearing which ought to have been given before the authority. Now, my lords, with that background, my lords, may I just first place, my lords, the discharge order and then the rule. Because, my lords, there was a submission made before the learned single judge that the rule 19 itself would require a hearing, an opportunity of hearing before, my lords, the order is passed. Single judge, my lord, with respect, did not even answer this issue. And this, my lords, in my respectful submission, is one of the major errors on the face, my lords, of the impugned judgment. My lords, with that background, will your lordships first come to the discharge order? That's at page 249 of my appeal. Yes, lordships has page 249. And Bonali, please hand over the Assam Transport Service Rules 2003 to my lord. (249).
Yes.
Let's. It's dated 21st January 2019. Your ladyship has it, my lords? I'm grateful. Whereas Srimati Suranjita Hajarika, that's my client, my lords, wife of Saurabh Kumar Rekha, resident of Kailipara, Guwahati, had appeared for the combined competitive examination 2014-15 conducted by the APSC. And whereas on recommendation by APSC by letter number so-and-so, Srimati Suranjita Hajarika was appointed temporarily as DTO as per the notification number so-and-so dated 15/10/16, who had undergone 2 weeks joint induction training course along with the probationers of ACS and allied services conducted by AASC Khanapara with effect from 18 to 28 October 16. And whereas after completion and release from the joint induction training course, white number so and so, dated 28 October 16, Srimati Hazarika DTO, probationer, had joined in the Commissionerate of Transport on 31st October 16 and subsequently was posted in the regular place of posting. And whereas, please mark, a report has been received from the Commissioner of Transport, Assam, white letter number that Srimati Suranjita Hazarika DTO Transport and so was arrested on 18/7/18 during her probation period in connection with Dibrugarh PS case number 936 of 16 under section 713(1) ABD2 of the Prevention of Corruption Act and sections 120B, 420, 463, 468, 471, 477A, 201 IPC, and detained under custody beyond 48 hours. And whereas during investigation, the examination conducted by the APSC, the answer booklets were seized under section 27 of the Indian Evidence Act from the confidential room of APSC building, which was of CCE M 2014-15 for the ACS and allied services, and was sent to FSL Guwahati for forensic examination by observing all the formalities. And whereas, please mark this, during the course of investigation, Srimati Hazarika District Transport Officer Sonitpur was arrested so-and-so for evidence opined by SP Dibrugarh for seizure of fake duplicate answer scripts. And whereas, as per report of Sri Surajit Panesar, APS, Additional Superintendent of Police Dibrugarh, Srimati Hazarika was placed under suspension by notification dated so-and-so with effect from the date of her arrest. And whereas another report along with the certified copies of relevant documents have been received from the Superintendent of Police Dibrugarh by letter number dated 24/7/18 with a request for sanction to prosecute the arrested public servant, Srimati Hazarika. And whereas, as per request of SP Dibrugarh, prosecution sanction has been accorded against Srimati Hazarika by notification dated so-and-so. In view of the above, it is found that the copies of records that the case of Srimati Suranjita Hazarika probationer is similar to cases of ACS, APS probationers since she appeared in the same CCE 2014-15 conducted by APSC and was selected. Now, the Governor of Assam, in exercise of powers conferred under Rule 19(1) and 2, please mark this provision, it's an exercise of power under 19(1) and 2 of the Assam Transport Rules 2003, is pleased to discharge Srimati Suranjita Hazarika DTO, Transport Officer, and DTO so-and-so under suspension from service with immediate effect. Let's I pause here for a moment. This order, my lords, is a detailed discharge order. This order refers to a case which is registered, my lords, namely Dibrugarh PS case number so-and-so. It refers, my lords, to offences under the Prevention of Corruption Act having been committed by the appellant. It refers to, my lords, offences under 420, 478, etc., my lords, under the IPC. It refers, my lords, to some disclosure statement under section 27, my lords, on the basis of which, my lords, the booklets were seized. It refers, my lords, to the investigation in Dibrugarh police station case, my lords. It refers to the sanction order, my lords, obtained against me. And in my respectful submission, my lords, on a plain reading of this order itself, this order is stigmatic. It is punitive in nature. And the test, my lords, which the Honorable Supreme Court has laid, my lords, is, will it debar her from future employment opportunities? The answer is yes. But nobody is going to know. Her career has been ruined. She has been condemned unheard by this order. It's an ex-party order. It's an unilateral order. And in my respectful submission, my lords, it is it is beyond, my lords, Rule 19(1) and 2. I'll make that good. Now, my lords, my challenge to this order is, my lords, straight away twofold. A, does Rule 19(1) and 19(2) entitled me to a hearing, an opportunity of hearing. If the answer is yes, this order has to go. Right, my lords? Now, second limb of my argument is this, my lords. Your lordships, my lord, my learned friend Mr. Chaudhary and Mr. Das has placed, my lord, the judgments. I will also place the relevant part. Purushottam Lal Dhingra, my lord, is the first judgment, followed by Shamsher Singh, my lord, Constitutional Bench judgments. And the law, my lord, which has developed is this, my lords, that if that the Article 311 protection, my lords, is available even to a probationer, these are settled law, my lords. Secondly, my lords, the order has to be seen, and if the reading of the order itself, it is stigmatic and punitive, then I am entitled to, my lords, the protection under 311(2). Otherwise, also, my lords, if your lordships are to see a simple innocuous order, my lords, there are some innocuous order if your lordships see at times, my lords, which gives no reasons, but yet, my lords, may be punitive. Then, my lords, your lordships have said, my lords, that we will see, my lords, what is the order by lifting the veil. That your lordships will lift the veil, and a innocuous order may turn to be punitive and stigmatic. When I'm on this, my lords, let me just place a few other orders. Will your lordship just have page 205 of my appeal paper book? Just, my lords, for an example, 205, 206, just have 205, my lords. I'm just, my lords, comparing it only to tell your lordship that this order itself, my lords, is punitive in my client's case. Just have 205, my lords. It's a three-line discharge order. Just see this, my lords. The governor of Assam, in exercise of powers conferred by Rule 20C of the Assam Civil Service Rules, is pleased to discharge so-and-so from service with immediate effect. So, my lord, this is what the Supreme Court has said, my lord, is maybe an innocuous order, for which your lordships will lift the veil. And by lifting the veil, your lordships will go through the records. And if your lordships see, my lord, that the records disclose that this in so-called innocuous simple three-line order, my lords, is in fact punitive and stigmatic, then 311(2) protection will be available. But in my case, your lordships will compare it with page 249. With 249. 249 is a detailed order, my lord. The reading of the order itself is stigmatic. I did not go further. It is stigmatic, it is punitive, and it meets the test laid down by the Honorable Supreme Court, namely that will it affect her future employment? Answer is yes. Nobody is even going to touch my client with a bird's pole after this order. And this is what has happened, my lord. She tried to go back to her job as a banker, my lord. The bank refused. So her career is ruined. She has been condemned unheard. And yet, my lord, the single judge says that very well, we have given you a hearing for 18 days. This itself is a substitute for the hearing which the authorities should have given in so many words not stated, my lord, but that's the tenor of the finding of the single judge. Now, my lord, I pause here for a moment and take your lordships to the rule. And when your lordships takes the rule, my lord, my respectful submission is this, my lord. Your lordships knows that, my lord, that Justice Vivian Bose's famous judgment, my lord, in Commissioner of Police versus Godhandas Bhanji, 52 Supreme Court says that the order will have to be, public orders publicly made, my lords, will have to be read as per the language of the order itself, and not what the officer later on said in an affidavit of what he actually meant by that order. So my first submission is, my lords, that your lordships will test the order on its bare reading. If on a bare reading, my lords, it is stigmatic, it is punitive, my lords, your lordships need not go any further. What the deponent explained, my lords, in the affidavit in opposition or the additional affidavit in opposition is irrelevant. My lords, with that background, my lords, please come to Rule 19, my lords. That's page 13 of the rules which my friend Barnali have handed over. Rule 19, your lords, page 12, it starts, my lords, put out the page. My lords, has it?
Yes, yes.
Yes.
We have
Beautiful. Discharge of the probationer, 19. A temporary or officiating member shall be liable to be discharged or reverted to the lower cadre of the service or to the original service if he fails to, not be, it should be he fails to make sufficient use of opportunities given during any training as may be prescribed by the government from time to time, or fails to render satisfactory service during his tenure of service in the cadre and or. So, though they are saying it's an order under 19.1 and 2, 19.1 on the face of it will not apply because it does not relate to her her conduct during the period of probation. Now, please have 2. And everything turns on the language of 2, my lords. It is found, my lords, please mark, my lords. It is found on a subsequent verification. Please mark this word, my lords, phrase, on a subsequent verification that he was not initially qualified for appointment or that he had furnished any incorrect information with regard to his appointment. So here, my lords, he has to be read with she, my lords, but that's fine. So as Rule 19.2, my lords, the plain language is if it is found on a subsequent verification that he was not initially qualified for appointment or that he had furnished any incorrect information with regard to his appointment. So, my lords, the requirements are it is found. So, my lords, there has to be a finding rendered. The words are explicit, my lords, and I would respectfully submit, my lords, opportunity of hearing has to be read into 19.2. Otherwise, my lords, 19.2 will have to be struck down as arbitrary and providing uncanalized and unbridled power to the authority. What I was saying, my lords, is the opportunity of hearing will have to be read into Rule 19.2. The wordings of Rule 19.2 itself shows, first, it is found. So, my lord, there has to be a finding rendered by the authority. And found where, my lords? On a subsequent verification. So, my lord, this subsequent verification is after the officer has joined the service. She is on probation. And during that probation period, my lords, on subsequent verification, it is found. So, my lord, my respectful submission is found means a finding has to be arrived at. On a subsequent verification, my lords, I will place, my lords, the Black's Law Dictionary and, my lords, the other dictionaries to show what verification is. Verification itself means investigation. It means inquiry. So, my lords, Rule 19.2 would mean this, my lords, that the employer is in possession of some material or information based on which a subsequent verification is conducted and it is found on a subsequent verification. So, namely, my lord, there is a finding in that verification process that I was not initially qualified for appointment, or that I had furnished any incorrect information with regard to my appointment. So, my lords, my respectful submission is, my lords, and I'll beseech your lordships, my lords, to interpret this provision, my lords, to hold that an opportunity of hearing, my lords, is provided or has to be read into 19.2. In fact, my lords, there is a very famous passage of Justice Biles, my lords, in Cooper versus Wansford, my lords, that's relied upon in Maneka Gandhi, that in case there is a silence, then the justice of the common law, my lords, will supply the omission of the legislature. So, assuming, my lords, that there is a silence by the rules does not say explicitly that an opportunity of hearing must be given. The law is, my lords, it's well settled, my lords, till recent pronouncements of the Honorable Supreme Court, that the justice of the common law, my lords, will supply the omission of the legislature.
Here,
Yes,
I have a query. It
Yes,
may
ma'am.
not be relevant for this matter, but I
Yes.
have a query here.
Yes, my lord.
You see, you have Evidence Act with you.
Yes, my lords. Yes.
This Evidence Act had section 2
Yes,
was repealed.
relevant.
The text of this is not now available in this Universal's book, but I have read it, and I have also posed this query in one of the orders passed by me.
Yes, my lord.
Sitting singly.
Yes, my lord.
This provision of section 2 in the Evidence Act
Repealed, my lord.
was that the laws prevailing in the
Jammu and Kashmir will not apply.
United Kingdom
Yes, my lord.
would be applicable.
Yes, my lord.
That was the original section 2.
Yes, my lord.
Only after that was repealed,
Yes,
the Indian laws became paramount.
very well. Yes,
Correct.
yes,
So this is number one. Now, therefore, when we take judicial notice,
yes, my lord.
we don't take judicial notice of laws which are prevailing in the
Yes,
United Kingdom.
yes, yes.
That's one. I found at least two judgments of the Constitution Bench where it's referred that the common law in England would be applicable. But apart from that judicial pronouncements,
Yes, my lord.
there's no substantive law which includes the law of the common law of England,
Yes, my lord.
the Indian legal structure. That's number one. Second is that none of us, with exception of people who have in fact gone to United Kingdom and have their education there,
Yes, my lord.
we've not been normally. I can say 95% of us are not trained in the common law of England.
Yes, my lord.
Now, just by a stroke of pen, can it be presumed that we must be always aware of the common law application and then apply it? And then the orders become assailed only because certain principles of common law was not taken note of while giving the judgment, because the law is that
Prevalent in India.
Judicial notice of the law of India.
Yes,
First is notifications, gazettes, and all. There are 13.
yes, yes.
Section 57 says 13 columns,
Yes, my lord.
13 clauses. So this is a query at your sweet time. You can give me a note, a reply. Not
I will,
regarding
my lord.
this case, but
On the first blast, my lord, my submission is this, my lord. In case there is a provision, my lord, which is prevalent under our Indian law, my lord, that provision will apply proprio vigore, my lord. Will not go into but for interpretation, my lord, what our courts have done is, since, my lord, we all, my lord, come out of the British system, my lord. So that way, my lord, our system of justice, my lord, is premised on the British system, my lord, common law system. We still follow the common law system, my lord. So for interpretation of a provision, if there is, my lords, any law available anywhere in the world, including America, anywhere, my lords, that is always taken, my lords, by our courts to rely upon. My submission is this, my lords. What I am saying is this. Assuming, my lords, there is no provision at all. I'm talking about this case, my lords. Assuming there is no provision, will your lordship still allow, my lords, today an administrative authority, an employer, to fire someone without giving a hearing? Law has developed, my lords. Initially, it was that principles of natural justice will apply to only judicial and quasi-judicial.
But look, the world's very vibrant democracy. In
Yes.
doing so,
Yes, yes. We are a very vibrant democracy, my lords. But
not ours. Not ours.
even we are, my lords.
Somewhere else, of which everybody now does not want to speak of. Hundreds and hundreds of people have lost their job, no job security.
No.
And that is accepted without any protest anywhere in the world.
No, my lords, what I was submitting for your lordship's kind consideration was, my lords.
No, we have it. I'm just posing this question.
No, I understand. That's
Not
very
in
important
respect of
question.
this.
And there are
Not in
decisions
respect
also
of
which
this.
says that we should not rely upon foreign judgments, my lords, ordinarily. But yes, my lords, in cases like this is not something which is new. So we take, my lords, benefit of any judgments, any law which is laid down. And these words, my lord, of Lord Justice Biles was in the 1600, my lords, which said that the justice of the common law will fill, my lords, the vacuum which has been left by the legislature. And this judgment, my lords, has been followed with approval in a number of judgments, including Maneka Gandhi, which says that if the statute is silent, your lordships will read, my lords, a hearing into that statute. Unless the statute, my lords, expressly or by implied limitations excludes such a hearing. Now, my lords, the latest DSMIT says that even impliedly is gone out now, because the law is developing, my lords. Your lordships have seen, my lords, in our country also, starting from Binapani Day, 67 Supreme Court said, my lords, that even administrative authority will have to follow natural justice. A.K. Kripak, my lords, these are all watershed movements in our judiciary, my lords. Maneka Gandhi. And law has developed till date, my lords, to say that principles of natural justice will have to be read into any provision which adversely and prejudicially affects the right of a citizen. If it adversely and prejudicially affects the right of a citizen, my lords, then the courts have held that principles of natural justice will have to be read into. This is a principle of fairness, that no person shall be condemned unheard. No, my lords, I was on Rule 19.2, my lords. And Rule 19.2, if your lordships come back again, my lords, stipulates that he was, if it is found on a subsequent verification, my lords, that's the second part of my argument on 19.2, my lords. First, 19.2, I said, my lords, that the words, it is found on a subsequent verification, means, my lords, that there is a finding rendered in an inquiry. Now, my lords, what is found? Rule 19.2 says, my lords, just have 19.2 again, my lords.
Yes.
That he was not initially qualified for appointment, or that he had furnished any incorrect information with regard to his appointment. So that not initially qualified for appointment one submission I'm going to make, my lords, for your lordship's kind consideration is not initially qualified for appointment would mean qualified in terms of Rule 7. Your lordships have Rule 7, my lords, which prescribed, my lords, qualification for direct recruitment. B, not qualified in terms of Rule 8, which prescribes academic qualification. And let's just have Rule 7, my lords.
Yes, we have it.
Yes, it says qualification for direct recruitment. So these rules prescribe, my lord, the qualification. Section 8 says academic qualification. 9 says physical fitness. 10 says character. So not initially qualified, my lords. The phrase appearing in Rule 19.2, my lords, I'm beseeching your lordships to consider, is not initially qualified for under Rules 7, 8, 9, and 10. Namely, my lords, he or she did not have the qualification for direct recruitment. That's Rule 7. Or he or she did not have the prescribed academic qualification, which can be in the case of a forced degree, or a claimed qualification which that officer did not hold. Or Rule 9, my lords, physical fitness, that he or she was not physically fit to have been selected for appointment. And Rule 10, my lords, that the character certificate which was given, my lords, was not correct, or that they have reports against his or her character. So, my lords, and the second and the last part of Rule 19 is, or that he had furnished any incorrect information with regard to his or her appointment. This would mean, my lords, either age certificate, either, I'm just giving instances, my lords, or the certificate or the academic qualification certificate is forged. And myriad other situations, my lords. So the discharge order, my lords, which I have placed at page 195, 249, does not fall, my lords, on a plain reading under 19.1. It's not their case that, my lords, there was something which rendered my service unsatisfactory, or that I'm failed to make sufficient use of opportunities given during my training, as may be prescribed. So at best, my lords, the order will have to be pegged down to Rule 19.2. And on a plain reading of 19.2, my lords, the grounds on which the discharge has been passed does not fall within 19.2. That's my second argument, my lords. Without prejudice to my first argument, that subsequent verification process which results in a finding, and it is found that on a subsequent verification would entail, my lords, an opportunity of hearing to be given. And if the contention, my lords, of the state is upheld, namely that Rule 19 does not provide for an opportunity of hearing, then in my respectful submission, my lords, Rule 19 will have to be struck down as conferring unbridled, unchannelized, and arbitrary powers. There is another line of looking at it, my lords, your lordship says, my lords, that there is, my lord, that my appointment was done, my lords, through an official process on the basis of which, my lords, numerous others joined the service along with me. So there is a presumption under Section 114E of the Indian Evidence Act 2 that official acts have been regularly performed. And to dislodge that presumption, my lords, the employer will have to give me a hearing. If any material has come in the hands of the employer to show that there was any discrepancy in my appointment, or that I entered the service without holding the requisite qualifications, etc., etc. So, my lords, this is, my lords, the first argument that Rule 19(2), according to the department, does not visualize an opportunity of hearing. So we don't need to give you a notice. We don't need to give you a hearing. And we are entitled to pass an ex parte unilateral order discharging you from service. That's their case, my lords. It's not even their case that, my lords, we tried to give a hearing, or that hearing would be an empty formality. That empty formality test also has now, my lords, been done away with. Their case, my lords, because your lordships will first, my lords, hold them on the language of the order itself. Your lordships will not permit them to explain what an officer later on thinks, my lords, what was the purport of that order. So if we go by the plain reading of the discharge order for the client, for the appellant whom I am representing, the order itself, on the face of it, my lords, is stigmatic. It refers to corruption allegations against me, my lords, in the case register. It refers to, my lords, cheating, forgery, etc., my lords. It refers to, my lords, some recovery made under Section 27. It refers to, my lords, the sanction order having been applied for and granted, and my prosecution in the criminal case. So, my lords, my respectful submission is that on a plain reading of the order itself, which is the first test which your lordships will apply, this order, my lords, is stigmatic. It is punitive. And therefore, my lords, the appellant was entitled, my lords, as a right for the opportunities and the right under Article 311(2). The second limb of my argument is, my lords, assuming, my lords, this order is not stigmatic, your lordships are to hold that this is not stigmatic, this is not punitive. Even otherwise, my lords, this order of discharge has humongous consequences, my lords, against the appellant. It adversely and prejudicially affects her rights. Her right to livelihood has been taken away. Her reputation has been severely damaged. So in view of such consequences which flow from this order, my lords, my respectful and humble submission is that I have a right to be heard. The law, my lords, is uniformly settled, my lords, that any order which acts to the detriment of a person, any order, my lords, which affects prejudicially and adversely, my lords, means it has civil consequences. And when there is civil consequences flowing from an order, my lords, a hearing is mandated. So on this ground itself, my lords, this order needs to go. The learned single judge, my lords, with respect, has not even addressed this argument at all. This was, in fact, my lords, one of the strong arguments raised, my lords. Your lordships will see, my lords, including Mr. Nilay Datta's argument on principles of natural justice. He relied upon, my lords, Mohinder Singh Gill's case, etc., to argue that an order which adversely impacts on a citizen has civil consequences. And the authority is under a mandate to give a hearing. Secondly, my lords, I pointed out that the effect of 19(2) itself, my lords, if your lordships Let's read the rule itself. Hearing has to be read into the rule. If an opportunity of hearing, Malats, will have to be read into the process of subsequent verification. And a finding arrived at, which is, Malats, which has to be read, Malats, in the rule 19.2, where it says, where it is found on a subsequent verification. So found means there is a finding arrived at on a subsequent verification, which is nothing but an inquiry or an investigation. And therefore, Malats, when you conduct that subsequent verification process, the employee has a right to be heard. And if that right has been infringed, Malats, this order on the face of it, Malats, is untenable and should be set aside on this ground itself. Well, we don't need to go into other aspects, Malats. Whether, Malats, it is punitive, whether it is stigmatic. And in this case, Malats, in my client's case, the lordship doesn't even have to lift the veil. The order is a detailed order, Malats.
We continue on Monday then.
Very well, Malats. I'll be there physically on Monday, Malats.
So, Kohli, Monday again.
Yes, Lordship, I was expecting it on Monday because Lordship has already indicated it will continue. I'm glad also my colleague has started today because broadly I do believe that after Arnab will finish, we will be on the a couple of more and maybe in a day or two, that side will end. Then I'll have to plan my coming to
Mr. Chaudhary, you'll have to give us a short note.
I will. I'm carrying everything.
The case laws.
Yes,
please indicate.
I will request him to also WhatsApp.
I will.
Paragraphs also, please indicate.
Yes, Malats. Paragraphs, Malats, with the proposition 2.
That will be very good.
I'll do that.
The Lordship, same 2 o'clock, Lordship, Monday?
Yes.
Grateful to Lordship.
Very well. I'm grateful.
But just remind us, we get carried away at times.
Yes, Lordship, we learned that the last time, and I think everybody on that side is duly reminding Lordship.
The earlier one was WA. Item 78. The submissions of Mr. NNB Chaudhary, Learned Counsel, in WA 47 of 2021 is concluded, reserving right to reply. Next, the submissions of Mr. A. Chaudhary, Learned Senior Counsel, assisted by Mr. B. Chaudhary, Learned Counsel for the appellant in WA 14 of 2022 remains inconclusive. Mr. N. Kohli, Learned Senior Counsel, assisted by Mr. H.K. Hazarika, Learned Government Advocate, appears through video conferencing. Mr. Prasad.
A. Roy and Miss N. Menon.
Okay. Miss Roy and?
Mr. A. Roy, Ankit Roy, and Miss N. Nimisha Menon.
Okay. You're then, Mr. B. Prasad, Learned Counsel in the WA?
Yeah.
50 is WA 98 of 2020 and W 196 of 2020 are present. Who else are present in this matter? Just get your names recorded, whoever are present. Since are present. Next part. This matter is started on Monday, 19/5/2025. For this, if be prepared.
Lordship, no, item number, Lordship, 59, Lordship. Bhaskar Chandra Dev Sharma. This person was
Just get your-
expired. As per information, this person was expired.
Item number
Item number 59,
59.
Bhaskar Chandra Dev Sharma.
Bhaskar Chandra, this one, he has expired.
Yes, Lordship.
Okay. You see, that is, your name I forgot.
Lordship,
Your name?
MSN Chaudhary,
Ms. N. Chaudhary, Learned Counsel for the appellant
appellant.
in WA 127 of 2020 has submitted that as per instructions received by her, the appellant, namely Bhaskar Chandra Deva Sharma, has expired. So what do you want us to do?
Lordship, matter may be as.
It will be closed as,
Yes, Lordship.
okay. So accordingly, she has instructions not to press this appeal. So accordingly, on the death of, in the reported death of the appellant, the WA 127 or 2020 stands closed. Closed oblique abated. Okay.
Grateful.
Grateful.